lived with him in his home.
Yes, ma'am.
There was a dispute.
I received partial or no rent payments.
As a result of this harassment,
That's correct.
ridiculous. Do you know my husband harasses me every day?
This is Judy Justice.
Is suing his former roommate, Christopher Robertson, for rent, a security deposit, and stolen property.
Court come to order. All rise.
Have a seat, please.
Kevin approaches the bench.
Hello, Judge. Case 2066, Michelonius versus Robertson.
Thank you.
You're welcome.
Mr. Robertson, how long had you been living in your apartment prior to renting a room to the plaintiff?
I believe it was about 3 years.
You had been living there by yourself?
No, I had roommates previously.
When did the plaintiff move in?
I believe that it was January 1st of 2017.
2017?
It may have been 2018. It was the first, I forget.
It was 2018.
That's correct.
How long did he live there with you?
He lived there with me until September of 2021.
So far, that correct, sir?
Yes, ma'am.
So now let me understand this lawsuit. Mr. Robertson lived in his apartment for 3 years. You answered an ad for a room. You lived with him in his home as a tenant from January 2018 until September 2021.
Correct.
At that time, there was a dispute. We will get into that in a moment. There was a dispute. During part of that time, Mr. Michelonius, you did not pay rent. Is that correct? During COVID?
That's correct.
For what period of time did you not pay rent?
Well,
Give me how many months did not pay rent?
there was,
You don't have to think out loud. How many months between January of 2018 and September 2021 did you not pay rent? Give me a number. That's a number.
4 months. Some months I paid partial rent. But there were 4 months that I did not pay any rent.
4 months, no rent. And how many months did you pay partial rent?
I believe that would have been 4 or 3.
So for 7 months, you did not pay your rent. Paying partial rent is not rent. Now, my question to you, Mr. Robertson, is this is an apartment that you rent
Yes.
or rented. From January 2018 until September 2021, was your rent current?
My portion of the rent was current.
What do you mean your portion?
My portion that I was responsible for.
No, it's your apartment. You're responsible for the whole thing, Mr. Robertson.
Yes.
Okay? You're responsible for the whole rent. And if what you chose to do was to say to your landlord, listen, I have a roommate, I'm just paying my portion of the rent, my roommate isn't paying his,
Right.
then your rent wasn't paid.
Yes.
And I assume that your rent wasn't paid for the same period of time that he didn't pay you his portion of the rent.
Yes.
Was it for any period of time greater than that? Greater than the 4 months or the 7 months that he didn't pay rent?
I went through my bank statements and they went back until, I believe, July of 2020. And that's as far back as my bank app lets me go.
Okay.
There were more months than that I received partial or no rent payments for.
From him?
From him.
I'm asking you about your landlord. If you didn't pay your landlord, you telling me your landlord didn't file an eviction against you?
There were several months that he did pay his full rent. And so that would have meant that the entire rent for that period.
Well, I know, but if the rent was not paid, did your landlord ever serve you an eviction notice?
No, there was an eviction moratorium in Alameda County at that point for unpaid rents due to COVID.
Gotcha. So that would it be a fair statement that you both took advantage of that? He took advantage of it, and so did you.
I wouldn't say that it was me trying to take advantage. I would just say it was my inability to cover the entire rent.
Your portion as well as his?
My portion was always covered.
Your portion was covered?
Yes.
Okay. Now, Mr. Michelonius, when did you move from month and year?
It was September of 2021.
And when did you leave there?
I believe it was the 3rd or 4th week of August of 2021.
So you both left the place at about the same time?
I left involuntarily, but yes.
Well, you left involuntarily, because that's what this case is about. Okay, so now I have the structure of it. Do you understand the structure of it?
I understand.
You understand the structure of it? I just want to make sure that people out there watching understand the structure of it. So you were the rentor, and you had an argument. It resulted in a protective order for somehow, some genius put him out of his own apartment because of these protective. You weren't in the hospital for anything, were you, as a result of an assault? No.
No.
You have no medical records there of being treated for any injury.
It was a harassment.
Just a minute. Do you know my husband harasses me every day? Every day. I couldn't think of evicting him. I mean, you do other things. So the answer is, you were never treated for any illness. You were never treated for anxiety at a hospital as a result of this harassment. As a result of your allegations, let us say of harassment, Mr. Robertson was ejected from his own home, from which you had not been paying rent, your portion that you were supposed to pay contractually with him for months because of COVID. Am I getting this story right so far? I'm not finished yet, but so far, is there anything that I said was wrong?
I think that's pretty close. I mean,
Okay, so that's pretty close. And now what you are seeking here is, should I say basically, and I hate that word, basically, but it's appropriate in this case. So all of those haters out there, she used basically, I don't care. It's appropriate here.
Whitney grins. Caption coming up.
and I put in the protective order that they were living with me, but they were moving.
No. They were living with you. You were living with them.
Well, yeah, we were living together.
No. You were living with the defendant. He wasn't living with you.
A courthouse. The Judy Justice logo appears. In the courtroom, Mark and Christopher.
Mark Michelonis claims his former roommate, Christopher Robertson, owes for rent, a security deposit, and stolen property. Christopher is countersuing, claiming Mark owes him for rent.
Now, what you're claiming in your lawsuit is that after a review of the copy of the underlying lease, you found that you were paying the vast majority of the rent.
Correct.
And so you want a return of that money.
That's correct.
Under what theory in the law?
Well, basically that he defrauded
No,
me.
now you can't use a basically.
Okay.
I want to know what theory is there in the law that says if I own a building and I lease to someone the whole building for $10,000, and then I find somebody who is prepared to pay me, and I have the first 2 floors of the building. 3rd floor is vacant. I find somebody who's willing to pay me $9,000 a month just for the top floor. That makes me a good business person. But unless there is something that prohibits him from doing that,
There is, Your Honor.
show me.
There's a clause in the lease.
No, just show me.
Okay.
I'm a lawyer. I can read a
So
lease.
the sublease that I agreed to with him incorporates the entirety of this master
Just a second,
lease.
I'd just like to see it,
Okay.
please, sir. I'd just like to see it.
Mark hands a document to Kevin, who brings it to Judy. She reviews it.
I assume you've highlighted what you want me to read.
Correct.
Okay. So what you're pointing to is that the landlord, his landlord, was not advised that you were subletting.
No.
Well, that's why signed by every tenant.
So that was one of the things, because if you look at the second lease, the one that was altered by Christopher to remove those areas so I wouldn't be aware, or I wouldn't be able to enforce them, was because he moved his boyfriend in without getting my consent. And so it says in there that he needs written consent. I understand that that doesn't apply to me, but he thought it did. And so he used whiteout on the other lease that I gave to you to obfuscate those terms.
I don't know how to put this to you, sir, other than to say, let me backtrack. What kind of work do you do?
I'm a web developer.
You work for yourself or for a company?
I do. I'm an independent contractor.
How long have you been doing that?
2 years.
Prior to that, what were you doing?
I was a system administrator
For whom?
for a small company in San Francisco.
How long did you work for them?
6 years.
So for 2 years, you were an independent web developer, and you're still an independent web developer.
Correct.
And that's how you support yourself.
Right.
So you work out of your home.
Right.
And you've been working out of your home, you said, the last 2 years since 2020. This is 2022 or 19.
Right.
What do you mean, right?
So it would have been.
When you
20
moved in 2018, were you an independent contractor?
No, I was going to school.
You were going to school?
Right.
For what?
When I went to,
Just
I
a
was
second, for what?
For web technologies. It was a program for web development technology.
Did you go in person?
Yes, it was an intensive.
For how long?
It was 3 months. it was 8 hours a day.
Okay, so you went to school for 3 months. During what period of time?
January 2018 to end of March 2018.
Okay, and at that time you were living with the plaintiff.
Correct.
Okay, so you needed a room for that 3-month period. And after that time, you supported yourself by being your own boss, by developing websites.
It took me a while to find a job, but yes.
What do you mean it took you time to find a job?
The interview process to get work, I was interviewing, it was very hard to break into that industry.
And so what did you do?
So I started taking on independent work.
So you never actually got a job outside of the independent work that you did?
That's correct.
So you support yourself by doing web development out of your home?
Yes.
So you used the home that you were living in, that room that you were renting, for not only your personal business, but you operated a place of business out of your residence.
Okay.
What do you mean, okay?
Yes.
Yes. I just want you to see how ridiculous you are. You want $10,000 because you overpaid what you consider your fair share of the rent. That's not going to happen. You come here, you didn't pay rent for at least 7 months because of COVID. You were working according to you. You were a web developer, still are. It's 2022 because you have no other job other than being a web developer. You stopped paying rent. You moved out after he did, correct?
Well,
did you pay?
I'd like to correct
in the
something.
month that you lived there, when you had put him out of his house because you were
they were moving out. I did not put him out of the house.
I thought that was a protective order.
It was, but they were, and I put in the protective order that they were living with me, but they were moving, and so.
No. They were living with you. You were living with them.
Well, yeah, we were living together.
No. You were living with the defendant. He wasn't living with you. You were renting a place, although you weren't paying rent from him, and the underlying landlord wasn't getting his money, all of his money, because he wasn't getting your money. And what's coming to me is that somebody got stiffed with rent, and that would be the landlord who rented you your place where you were living, because you didn't pay him the whole thing. You didn't pay him the whole thing. And now you want me, you're asking me, to award you $10,000 for overpayment of rent.
Your Honor, could I clarify something? The times when I didn't pay rent, I was not working. It was during COVID, so the first couple months of the COVID lockdown, I lost all of my contracts, so I didn't have any money. And so I was using there was a COVID process where you could, basically say that,
There's no basically in there, only I used it once.
So I did not have the money to pay rent. I was not just making money and not paying rent. I would not do that. I was broke. All of my contracts dried up because nobody had any money. I was working for small
So what are you
companies.
suing him for now? The government was very good to you. This is a very interesting America. It's a rent forgiveness, a rent moratorium. That doesn't mean the state where you live. What state do you live in?
California.
California. That doesn't mean the owner of this premises was given some sort of a break that they didn't have to pay for utilities, taxes, mortgage on the building, because it's used as a business. As far as I know, there wasn't a moratorium on that, but there was a moratorium on two seemingly able-bodied people to say to the landlord, I can't pay my rent. To add insult to injury, you think that I'm going to give you $10,000 because he charged you more than whatever the third or 40% of your occupancy of the apartment, and he shouldn't have? That's not going to happen, sir. So forget it.
Mark lowers his eyes. Caption coming up.
I've been here a long time. If a landlord is owed $5,000,
Yes.
he doesn't say, well, tenant owes me $5,000, but his apartment was clean. I'm going to give him back his $2,000 security deposit. That doesn't happen.
A courthouse. The Judy Justice logo appears. In the courtroom, Mark and Christopher.
Mark Michelonis has accused his former roommate, Christopher Robertson, of overcharging for rent and keeping his property. Christopher is countersuing Mark for unpaid rent.
Now, you gave him a security deposit. That is part of your lawsuit.
Correct.
So I want you to forget the overpayment of rent because it is ridiculous.
Okay.
So now let's go to the security deposit part of your complaint. Did he give you a security deposit?
He did, Your Honor.
Now, he didn't pay rent because of this moratorium
Yes.
on rent. Did you get your security deposit back from the landlord?
I did.
How much?
I believe I got the total amount for the entire apartment, which was approximately $2,000.
And how much did Mr. Michelonis give you as a security deposit?
He gave me $1,250 for the security deposit plus a $300 pet deposit.
Sometimes the pet deposit is refundable. Did you get the pet deposit back?
I don't recall specifically if I got that back from the landlord.
But you did get back your entire security deposit, which included his $1,250.
Yes.
Okay.
That's correct.
Let's hold that in abeyance for a moment, because now I'm going to go to your counterclaim.
Sure.
I think that's all I have to deal with. Oh, and property taken without permission. Did you get that property back? There was some...
I did not.
What property was it?
There was a stone Buddha carving. There was some dishes, some glasses.
Oh, give me a break. Do you have a stone Buddha carving?
I have the stone Buddha carving. I have a small statuette of a rooster that is his, and a small metal
Great. Would
serving
you
spoon set.
pack those up?
Yes.
Do you live close to each other?
I haven't been able to because of our mutual restraining orders.
Fine. Do you know where your local precinct is?
Yes.
Where is it located?
I believe that the closest one would be downtown for me, downtown Oakland.
Okay. You'll find out before you leave today. In 5 days, drop it off at the local precinct.
Absolutely.
Let him know when, and he could go pick up his Buddha.
Yes, I don't want
Great.
bad in my home.
Terrific. Now, money owed for COVID debt is your counterclaim,
Yes.
which is what?
It
how
is
much-
a total of $55.35, I believe.
For what?
That is the unpaid rent.
But you didn't pay his rent, you just told me.
Right, and so this is the outstanding balance of the rent that he never paid that I'm responsible for as the master tenant.
Oh, no, you just told me that you got your security deposit back. If you got your security deposit back, sir, that means that the landlord is finished with you.
According to the law...
Not
I mean,
according to the law. If you got your security deposit back, the entire security deposit, the landlord has written it off, because otherwise he would have taken your security deposit if you owed him or her money. Do you understand what I'm saying? It's very simple.
I understand
it's
what you're
very
saying.
simple.
I wish I could explain that to them in your
Well,
in your manner.
I want to tell you something. I've been here a long time. If a landlord is owed $5,000,
Yes.
he doesn't say, well, tenant owes me $5,000, but his apartment was clean. I'm going to give him back his $2,000 security deposit. That doesn't happen.
So would it
Only
be-
in the land of Oz does that happen.
They might live there.
No, they might live there, but I don't live there. Okay. You owe him $1,250 for security deposit. This case is over. Your counterclaim's dismissed. We're finished. We're
Court
done.
is adjourned.
Thank you very
Ma'am,
much.
I would just like to bring...
Bye.
Well, I was a little upset.
He's being a drama queen.
The clause in the lease was to prevent people from basically taking advantage of the fact that they've been living in a place for a long time and gouging rent for new tenants.
He said I was price gouging him because he was enough to pay more rent than he might have if he had done some more research.
They were trying to make it equal, and every place that I've lived in, there was always an equitable share of the rent. Like, no one was ever gouging anybody, so I felt that I was unjustly charged.
Well, I can't say it wasn't very satisfying to hear the judge call his claims ridiculous to his face.
Basically, he was leaving the front door open, making it so my dog could escape easily. He was filling the house up with smoke.
We both burned sage.
He was basically trying to get me riled up. He wanted me to move.
While I am disappointed that I won't be able to recover some of his COVID debt,
Basically, the moment that he was, it was inconvenient for me to be there, he tried to make my life miserable.
I'm glad that I will never have to see him again, and this is done.
I'm not living with roommates ever again. I've got my dog, and we're cool.
He was a nightmare, and I never have to see him again.
Judy.
You know, far be it from me to second guess another judge, but it would seem to me sort of outrageous unless there was some sort of a physical altercation. Why anyone, because he clearly was excluded from his house. He left first, and he said, involuntarily. Would anybody exclude
The original tenant.
the original
When I read the
tenant?
papers, I thought the same thing. I thought that was outrageous that they would throw out the primary leaseholder on a lease in favor of his subtenant, which may or may not have been legal to begin with.
I can understand it if there was something more serious, but harassment, I just don't understand it. But
I didn't
mine is not to wonder why. Mine is but to do what I do. And I don't think that when you come into a court where you have at least participated marginally in a giveaway, to then come in and say, you know what, there's a technical thing. He wasn't supposed to charge me this much rent because I didn't occupy this much of the apartment, whatever. ridiculous when you didn't pay rent
Exactly.
for 7 months anyway. It made my job a lot easier.
Title: Judy Justice.
Want justice? Go to judyjustice.tv.
How many units did they paint for you?
They didn't finish any of the units.
That's incorrect, Your Honor.
Did you pay them any money for painting, yes or no?
No.
He told me that the job did not have to be perfect.
A 9-year-old can smear paint on a wall. Get somebody who knows what they're doing.
This is
For Judge Judy.
Previously on Judy Justice.
You were looking for a job. And what were you supposed to do?
Bartend, close, open, and run the concession stand.
I want you to do a step-by-step why you contacted the authorities.
Chris was still giving out free alcohol to people, pouring it, wasn't even checking people's IDs. So I called the ABC and I said, I think there's suspicion that he's giving minors alcohol.
And that was very distressing to you. So distressing that you said to him, do you have any other work for us?
Yes.
And did he say, I have an apartment complex that needs painting?
Yes.
And it was after the painting kerfuffle that you called alcohol beverage.
So we shouldn't have
Nobody was
reported it at all.
No,
we shouldn't have
no, I'm
reported it?
trying to get to your motive, sir.
And now, the conclusion. Noah Joyner and Harlan Hendrickson have accused their former employer, Christopher Ricks, of vandalizing Noah's car and refusing to pay wages. Christopher claims they slandered his business.
Now, you have photographs of the place before you started painting and afterwards? You have any photographs?
Absolutely.
I'd like to see them.
Christopher produces a photo.
It's just the paint on the floor.
Just a second.
Okay, very well.
I have eyes. I can look at the pictures.
So the
I
top
just want to
parts
take a look. If
are
I need any,
how they are before we paint them.
Noah hands photos to Kevin, who brings them to Judy. She reviews them.
That's before they're painted, Your Honor.
these are your photographs.
Yes, ma'am.
You painted the floor.
No, ma'am. We had to declutter a couple of units that had stuff.
One unit.
Like that.
Shh, don't speak. You had to, what you call declutter, and you had to sweep it up before you started painting.
It was worse.
Okay. And did you?
Yes, ma'am.
And is this a picture of what you allege it looked like?
All of the units had stuff in them just like that. Yes, ma'am.
Okay. And this is the floor that you painted?
Yes.
Is that the floor that they painted?
One of the three.
Okay. So they painted the floors. Did you paint anything else other than the floors?
Well, we painted the walls.
They painted the walls.
Sorry,
They
it
dripped
was
on the floors, Your Honor.
Okay.
They're brand new flooring.
We were
but
told
that
it
just-
wasn't. It didn't have to be perfect.
Just a second. You didn't put these floors in, did
did.
you? I thought they painted them.
No. They were to do touch-up only, and there was one unit that needed to be finalized, and that was the one you saw that was bad.
We were having
and
to
the
prime
floors
and
were
paint
Duh,
walls.
I told you, don't speak when he is. I'll come back to you.
the floors were brand new, and like I said, I provided drop cloths and such. They didn't use them.
That's
What-
not true, Your Honor.
Shh. What is this?
That's the one unit that was not that wasn't
was not
completely
just one
emptied
unit.
out.
Okay. This one,
Yeah, there was one single unit.
and this one,
That's the same unit.
and this.
Same unit.
Okay. And the rest of them were cleaned out.
Yes, ma'am.
Is that correct?
All new flooring.
Yes, the pictures of the yes.
The pictures of the mess are all one
unit,
unit of the 20. Okay. And how many units did they paint for you, Mr. Ricks?
They didn't finish any of the units. They were
Okay.
in 3 units, Your Honor,
Okay.
and 3 units have damage.
That's
Okay.
also incorrect.
What you're telling me is they didn't do a good job in 3 units.
Correct.
Okay. Well,
They
that,
didn't
sir,
finish it at all.
that, I'd like to see the photographs of what they didn't finish.
The paper copies. There you go. And there should be one that's a door that's not even painted. You can see it's two-tone, and the flooring is where they, I guess, scraped the floor.
Okay, this is the same picture
There's
as this.
No, that's different. I can show you on my phone too if you'd like. They're different. It's like in one of the areas they tried to use a tool to scrape paint off in different areas, and that's what was left.
Incorrect.
You're
You didn't
talking about-
provide me with any
That's not
tools.
true. There was no tools provided for us at all.
Justice, I didn't ask you anything. Is what you're saying to me, sir, that the reason you didn't, I assume you weren't paid for this work, is that correct?
Your Honor.
Not even for cleaning out that unit, really.
Weren't paid. Now, I assume, Mr. Ricks, that you didn't pay them because you thought that they did a poor job.
No, ma'am, that's not accurate.
Why didn't you pay
They
them?
didn't do the job.
They worked there at some point.
I agreed with Harland only to pay him $3,000.
Harlan, that was you.
Yes.
That's you. You agreed with Harlan.
For that job,
Yes.
Your Honor, that's
for
incorrect.
$3,000.
You're almost finished. Do you understand? You're almost done. 1, 2, 3 warnings, then I'm finished with you. And it wouldn't bother me at all. I have to tell you, it wouldn't bother me at all. Now, what arrangement did you make as far as payment is concerned?
On June...
Mr. Hendrickson started the job first on June 23rd.
He was to meet me, and he did. He was late. He was supposed to meet me early. I showed him the whole scope of the project because he hadn't been there, and what I wanted done, what I expected, and we agreed on the price of $3,000. And after they got halfway done, which was 10 units, I would pay them $1,500. And then when they were complete, I would pay the entire $3,000. They didn't get past 3, Your Honor.
3 of the 20.
Yes, ma'am, and they didn't finish any of those at all.
Okay. What I'm saying to you, Mr. Ricks, you took one guy
Right.
who you didn't know from a hole in the wall.
Yes, ma'am.
You took a second guy who you knew was there because I believe that you knew he was there painting with Mr.
Right.
Joyner.
Mr. Hendricks actually fired him twice. You can see in text message if you need to see that.
You mean Mr. Hendrickson fired Mr. Joyner?
Yeah, he says right here.
Oh,
Correct, Your Honor.
just a second.
Well, let me just pull up the text message since it's so
But you
accurate.
do know that Mr. Joyner was there.
Yes, ma'am.
Okay.
It was a group. They decided to do a group thing. This is right here it says, never mind, no one's
I
not
can
going to
read.
help me
He's done the
anymore.
group chat.
And then there's an additional where he says again that I'm going to let Noah have a couple of days off.
Just a second. Mr. Hendrickson, so on the 29th, you indicated to Mr. Ricks that Noah, that would be you, is not going to be helping me anymore.
Yes.
Yes, and you want to tell me why?
Noah and I had
No, look at me.
Noah and I had an argument at the painting job
Tell me
because
about
we were
the
arguing.
Tell me about the argument, sir.
We were
When did you have
arguing
it?
about the detail that we were putting into our work. I walked in and Noah was paying a lot of attention to detail, and Chris told me that the job did not have to be perfect. He just wanted it to be
Just
done.
a second. So Noah was trying to be careful,
Yes.
and you said you don't have to be so careful.
Yes, Your Honor.
Is that what it boils down to?
Yes, Your Honor.
And that was on the 29th.
Yes, correct.
So after that, he said he's not going to work for you anymore.
Correct.
Now, so I gather from that statement that since you were working there since the 23rd, you didn't feel as if you had to be so careful to detail.
That is
I mean, that would follow from what you just said to me. If Noah wanted to be more careful to detail, you say, oh, no, you don't have to be so careful to detail. It doesn't have to be perfect, right? And goodbye, which is what this says. So I have to assume, conjure up in my mind that if you doesn't have to be perfect, doesn't have to be such a great job. It can be, as my great-grandmother used to say, there's a difference between a schmearer and a painter.
That's right.
Now, I don't know who would understand that except another Jewish grandmother. But you understand the connotation. You can smear paint. I have a 9-year-old granddaughter who can smear paint on a wall. But if I want something professionally done, I try to get a painter.
I told Chris I was not a professional.
Just a second. You see, that's my problem with Mr. Ricks. If you want something done right, get a man, not a boy.
Christopher nods. Caption coming up.
Tell me the worst thing he told you to do.
I don't know what you were wanting from me.
What I want you to do is to tell me what he told you about black mold. Don't make it up.
A courthouse. The Judy Justice logo appears. In the courtroom, Noah, Harlan, and Christopher.
Defendant Christopher Ricks claims Noah Joyner and Harlan Hendrickson slandered his business on social media. Noah and Harlan say they were not paid for painting Christopher's apartment complex.
Now, if I wanted somebody to work on one of my cars, I would not get somebody off the street who was selling popcorn at a concession stand and say to them, by the way, my car over there needs a new battery. Now, would I take my car back to the same dealership? Maybe not, because they're very expensive. But would I find somebody who at least had a referral, a recommendation? I have a 20-unit apartment complex that was empty. You want to use it as a business. You don't hire 2 schmearers to go and take care of your property. But you have to, if you didn't like their work, fire them. And if their work was not complete and only 3 units were touched, which I don't think that they argue with. So far, that's correct, Mr. Hendrickson?
That is incorrect.
How many units did you
5.
paint? 5.
And I actually painted 7, but I didn't complete the last 2. I just did the trim in it.
So you completed 5 units out of 20.
Yes.
I'm giving him the benefit of the doubt. And you agreed to $3,000.
That's incorrect, Your Honor.
How much?
We did not have a meeting to talk about a payment until the 29th, and that was actually part of the reason that him and I were arguing. Chris and I and Noah met at a coffee shop, and we spoke about how much we would be getting paid. We agreed on a $3,000 price for the end of the month of July because Christopher was supposed to be going on a vacation until July 20th.
So the $3,000 was mentioned.
It was mentioned, and then he told me and Noah, Chris told me and Noah that on the 30th, he would pay us half of what he was going to be paying us.
Just a second. You were hired to paint 20 units.
Yes, Your Honor.
You painted 5, which is 1/4 of the $3,000.
Yes, ma'am.
Let's say those apartments were complete, not satisfactorily to him, but now you both agree that the $3,000 price was mentioned for the 20 units.
Yes.
It would be $750 if they did 5 units.
That's all, $750. That would be $750 if you completed only 1/4 of them. Okay. Did you pay them any money for painting, yes or no?
No.
Okay, good. So best case scenario for the painting is $750. And I haven't gotten to his counterclaim yet, but you have one more claim. And your claim is that Mr. Ricks vandalized your car by throwing paint on it.
Sure.
Tell me when that happened.
We woke up July 20th, 2020.
7:20. Where did you wake up?
At our house, our apartment. Hot Springs,
Okay,
Arkansas.
tell me what happened.
I woke up to my car being splattered with the same color paint that we were using in his apartments.
Okay, so your car had paint on it when you woke up. Did you see anybody do it?
No, ma'am.
Just let me take a look at the photograph.
Noah hands a photo to Kevin, who brings it to Judy. She reviews a photo of a paint-splattered car.
Okay. Did you file a police report?
Yes, ma'am.
I'd like to see it.
Noah hands a document to Kevin, who brings it to Judy. She reviews it.
Okay, so no one saw this, but you say that there is a video that you have. I assume, Mr. Ricks, unless you want to tell me that you did, in fact, throw paint primer on his car.
I absolutely did not.
Okay, and you did not see anybody throw paint primer on the car. But you say there was a video. Noah stated that he has video from his apartment complex pointing right at Noah's vehicle.
I think the police put that in there because they had interviewed.
So there is no video?
No, ma'am.
And you did not witness this?
No, ma'am.
And other than thinking that this paint primer was a result of actions and retaliation for something that you did, do you have any witness that saw him do that?
No, ma'am.
I have to see proof that the defendant had anything to do with this car.
Yes, ma'am.
Okay? Did you take the car in to be cleaned?
Yes, I cleaned it myself just to avoid further damage.
Yes.
But after I cleaned it, I took it to the auto body shop to see what the actual repairs
Okay,
were.
do you have pictures of it after you cleaned it?
After we cleaned it, it looked somewhat like this. And then we had to take it to the body shop. They buffed out the rest of it for us.
So what you're telling me is you took it to an auto body shop, and the auto body shop...
They helped clean up the rest of it, but they still took off our top coat.
Okay, very good. Well, you have no proof he did it. So far, he owes you $750.
May I interject that he doesn't even own that car?
I don't care. I'm not giving him any money for the car. There's no proof you did anything to the car. Okay, I'm not going to get into filing a false ABC complaint with the sheriff, because he's not going to be able to prove to me that it's true other than by what he says are his own observations. He doesn't have anybody here who's under the age of 21 who's going to testify that you served him alcohol. So I'm not going to entertain that part of your claim. Money owed for slander, that I would like to see. That's your cross complaint. So far, plaintiff has $750 for painting 1/4 of the places that he was contracted to do.
This is the first document, and I had calls just pour in, wanting to know if I'd seen it. And
Just
then,
a second. Don't tell me you had calls pouring in, sir, because that's
ma'am.
hearsay. What's the date on this? This one that I'm reading. I says 1 day ago.
It was around the first couple of weeks of July.
Okay. I'd like you to tell me, Mr. Joyner, the conversation, where it took place and under what circumstances, when you had a conversation with Mr. Ricks about covering up certain hazards. I'd like to hear that.
What would you like to hear?
I'd like to hear where the conversation took place, exactly what you said to him and what he said to you.
Where it took place?
Yes, where it took place, exactly what you said to him and exactly what he said to you.
I'm confused. So, like, what is?
We are on now.
I know the post about
a post.
Yeah.
We're on now a post. So I want you to tell me when you had the conversation where you were and what you said to him, mostly what he said to you, about covering up certain things with paint.
Okay, yes, ma'am. So we were told to cover up holes and stuff with caulking and then paint over it. And then we were told that
Now look at me.
I was told to go declutter one of the units that had a bunch of old parquet tile, ceramic tiles piled high to the ceiling with old ceiling fans deteriorating.
That was the unit that was on.
Right.
Go ahead.
Right.
And
so he told me that
I want you to tell me the worst thing he told you to do in the apartment complex. Tell me the worst thing he told you to do.
There was a lot of terrible.
No. Just stop and think of what is the worst thing he told you to do, the worst instruction he gave you.
Pretty much that I should just do it without the proper protective.
No, that's general, sir.
Okay.
I asked you specific. You posted something about him, about his apartment complex, about the work that you were doing, and I want you to tell me the worst thing he told you to make short shrift of or to cover up.
Water damage, black mold.
Okay, let's go to black mold. When did you have a discussion with him about black mold? Where were
He
you?
told me to declutter the apartment. So that would be Wednesday, June.
So there was one apartment that he told you to declutter. Okay, and that would be June what?
Monday, June 27th. I think that's what that.
Was he there in person?
Yes, ma'am.
Okay, so I'd like you to tell me what he said to you and what you said to him.
Told me to go.
Look here.
Told me to declutter the unit, take out all of it, throw it away, and to just.
No, don't look over there.
To clean, just to clean it, basically.
To clean it.
So that it would be ready to be painted.
And?
I did. I cleaned it.
And?
I'm done.
You done?
I don't know what else to say. That's.
Well, I want you to clean it. Doesn't tell me anything about black mold.
I don't know what you were wanting from me.
What I want you to do is to tell me what he told you about black mold. Don't make it up.
Caption coming up.
Your post, based upon your testimony, was slanderous.
I got confused. I don't know what you were really trying to ask out of me.
I asked you specific questions. You gave me answers. Now is not the time to play catch up.
A courthouse. The Judy Justice logo appears. In the courtroom, Noah, Harlan, and Christopher.
Defendant Christopher Ricks claims Noah Joyner and Harlan Hendrickson slandered his business on social media. Noah and Harlan say they were not paid for painting Christopher's apartment complex.
Now, tell me what he told you about black mold.
He didn't tell me anything about the black mold.
Great. And what did he tell you about rat feces?
Didn't tell me anything about rat feces. I handled all that stuff without me.
Shh. Then you did that all yourself. Well, in this posting you said, Chris, that would be you, wanted us to paint over chips, possible, dust, maybe, mold, never. He never told you that. That's what you just told me. Black mold, rat feces, and urine. He never told you to cover up those things. You may have done it, but according to you, he just said, clean it.
He had told me to cover up the mold that was in the
I don't
utility
believe that.
closets of the apartment.
Oh, I don't believe that. In a second. That's Mr. Joyner.
Yeah, it was Mr.
No,
Joyner,
this is
but
Mr. Joyner's
trying to communicate
post.
together.
And he never told him anything. According to him, he said, just clean it. You have the second post?
That one was taken down, and this is the second post that he reposted, and then his account got blocked because they don't allow that type of behavior.
Kevin brings a second document to Judy.
This is the next one, and this is where he claimed to be a bartender on Facebook, and he just took it down recently. It's been up there for months, and I never hired him for a bartender.
That's all right. I don't care. That's not important.
Okay.
What I'm concerned about is what he says that you told him to do, which you did not.
Right.
He acknowledges you did not. Now, You have no witnesses here.
I was going to bring one person, and she's got COVID.
Shoulda, woulda, coulda. You have
yes,
no
I have
witnesses
no one.
here.
I have no one, Your Honor.
Very good. Okay. I find that the things that you posted are slanderous with regard to what he instructed you to do, Mr. Joyner. You were the posting person as far as covering up black mold, feces, and urine, and therefore to beware of Rick's Realty. Your post, based upon your testimony, was slanderous because he never told you that. So.
But you never really cleared that. I'm sorry. You never really cleared it up. I got confused. I don't know what you were really trying to ask out of me.
No, just a second.
It was
I don't care
told
what.
to me that I needed to take care of all that stuff and throw it away. Yes, ma'am. It was told to me that.
Just a
That's
second.
why I posted. It was a warning as to so no one else would have to deal with that same stuff.
Very good. Very good. I'm ruling now, so now it's my time. I asked you specific questions. You gave me answers. Now is not the time to play catch-up. I find that by posting that he instructed you to cover up black mold, people responded to, actually, and rat feces, I don't know how you cover rat feces and urine with paint, and to stay away from his place of business without cause, because what you told me was, he told me to clean it up, that's slanderous. And so on the counterclaim that he has for slander, I am awarding him $2,750. That's a net to him of $2,000 because your claim of $750 for wages is absorbed by his counterclaim. So on your claim, you get zero, zippity-doo-dah. I'm awarding him $2,000 for slander. We're done here. Thank you very much.
What about the damages,
We
Your
are
Honor?
finished. Hire a professional, Mr. Riggs. You want a schmearer, that's what you get.
This court is adjourned.
Noah, then Christopher.
Regardless of terminology and how things got messed up, why would you expect someone to clean up rat feces, all of this stuff, and do it for free?
It's clear no good deed goes unpunished. I tried to help those kids.
Don't understand any of this, really.
Well, they were trying to extort money from me and not do work and be lazy and just get paid for work they didn't do.
We're trying to move on.
We're going to move on.
You kind of try to give people chances when they're down on their luck. I've always been a philanthropist, try to help people out, and sometimes you get burned.
Judy and Sarah.
First of all, if you're an employee and you're working either by the hour or by the day, you're not a weekly employee or a bi-weekly salaried employee, you're supposed to keep track of the hours where you work, especially if you want to, if there is a potential of suing later for them.
As the plaintiff, that is your burden. I was interested to see that you were willing to take that information from the defendant, because if it were me, if the plaintiff didn't have it, that's not the defendant's burden to prove
that's
the
actually
plaintiff's
true.
case. So I knew you did it to sort of round out the sides of the case, but I think that if you as the plaintiff want to come here and ask the court for money, you better have your ducks in a row. And
Well, that's true. That was true. That was probably an error for me. Not that he got anything, but
we got where we needed to go.
we got where we needed to go. But that's true. It's not the defendant's burden.
Yeah.
Although the defendant acknowledged that he worked for him.
He did. Very forthcoming and honest. So, but that, again, played better for the defendant, as we saw in the ruling, that he was
You're
professional.
supposed to have your ducks in a row.
Yes, and as a plaintiff, you don't get any money if you can't even keep track of the hours that you work.
The second thing is that the call to alcohol and beverage, if you feel as if you're doing a public service by reporting behavior that you think could be potentially dangerous, I support that. But if you're doing it as a retaliatory act and you don't do it immediately, it's like reporting suspected child abuse. If you see a child being abused or neglected and you do nothing and wait a month until you have a fight with the person who is the abuser, that creates a suspicion that it's vindictive and there's a motive to lie.
Of course.
Because it wasn't done immediately.
And they sought another job from the same man after reporting him.
Right. To the defendant's detriment, in my eyes, is if you have a big apartment complex and you have guys who were in the jewelry business and didn't make it, then came to work for you in your theater and really weren't very good at that either, then I wouldn't hire them to house paint.
Yeah. That actually requires a skill.
Without any credentials. So I think that you have to be careful if you have a valuable piece of real estate.
Agreed.
Anyway, he can't slander him, and he did.
I think it all worked out how it was supposed to.
I hope so.
Title, Judy Justice.
Have you been cheated? Go to Judy Justice.
He'd gotten a restraining order against me.
Against you.
I sent him a letter saying that I wanted payment.
This letter threatens to go to his boss to get him fired. That's what that says. That's what you were threatening.
This is Judy Justice.
And Tina Smoody are suing their former son-in-law, Dalton McDonald, for unpaid loans.
Court come to order. All rise.
Judge Judy.
Have a seat, please.
Kevin approaches.
Hello, Judge. Case 2082, Smoody versus McDonald.
Thank you.
You're welcome.
Mr. and Mrs. Smoody, the defendant used to be married to your daughter.
Yes, Your Honor.
And according to what I've read, they were married for about 5 years.
Yes.
The thrust of your claim is that he owes for a couple of things, for rent and the balance of a truck. That's your lawsuit against him. I'd like to know, do you know the date of their marriage?
3/16/2011.
And your ex-wife's first name?
Jacqueline.
And when did you and your former wife separate?
In 2020.
And you had 2 children. How old are they now?
They are 5 and 8.
And who has custody of the children?
Dalton has physical, and they have joint custody.
Just a second. So he has custody of the 2 younger children?
Yes.
That's a yes. How long have you had custody of the 2 children?
Since July of last year.
At some point during the marriage, there was a truck purchased.
Yes.
Who purchased the truck?
Dalton purchased the truck. I co-signed for it.
And when was it purchased? Month and year?
June of 2017.
Was that the only car
Yes.
that they had?
Yes.
So that was a family car.
Yes.
And in 2017, was your daughter working?
Yes.
So both parents worked. And both parents, I assume, pooled their money and I assume made car payments.
Yes, Your Honor.
Yes.
Is that correct? Both. And then they separated in 2020, and at that time, the children came to live with you.
Correct.
And you took the truck
Yes.
by agreement with your now ex-wife.
Yes.
In 2020, who made the car payments?
My husband did.
Is that correct?
Yes. I made all of the car payments on that vehicle, all of them, from the time it was purchased until we paid it off.
Okay, so what you're telling me is from 2017, you made all the car payments.
That's correct.
Did your daughter and son-in-law make any of those payments?
Not directly, but they paid toward the balance of the money that they were.
You
Okay.
paid for the truck
That's correct.
since 2017, since they
correct.
were married,
Yes.
with no reimbursement.
I took payments out of my daughter's check.
Just be very, very careful with me, sir.
Yeah.
I want you to be very careful with me. I read that, what we call in Yiddish, Bubameises in here, that you took money out of your daughter's check. Bubameises, it means grandma's tale. It means it's not true. It means it doesn't sound right to me. I read it in here. Don't try to repeat it here because that won't be good for you. Okay, I'm going to believe you if you show me copies of her checks that you made to her with withdrawals from money she owed you. That's all I want to see. Do you have that?
I do not.
Not, of course not. Now, he has the truck, and this was clearly either a gift or a marital debt. Either one of those 2 things. It's either a gift or a marital debt. It was a family car that was used by your daughter, her husband, the grandchildren, with, according to you, no reimbursement, according to you, except this ridiculous reimbursement from your daughter's check, which I don't believe, so I'm not even going into it, with no reimbursement 2017, 2018, 2019, 2020. And when your daughter and the defendant separated in 2020, according to him and according to you, he took the truck and the children. And that was with her consent or not?
Yes, it was.
With her consent. Is that so far right? That's what you're telling me.
It's accurate.
Right. Did you intervene in the divorce proceeding and say that there is money owed, marital debt owed, and part of the marital debt is this loan on the truck?
No.
No, no. The answer is no, you did not. It would also be fair to say that you don't know how much, according to you, she paid for the truck.
I do, Your Honor. I have
Well-
that ledger that I have. I would go to her each week and say, Jacqueline, how much can I take toward the loan? And that's how much I would take off each week.
All you have to do, sir, is show me. Otherwise, this is a whole bunch of nonsense.
Yeah.
It's a marital debt. You did not intervene in the divorce proceedings and say, listen, this is a debt that's still outstanding, whatever it is, $2,000, $3,000, $4,000. You didn't do that. Now, the only thing that you can say to me with regard to this truck business is if you had an agreement with the defendant in 2017 to pay the truck. And be very careful, because what you've told me is he didn't make any payments to you from 2017 ever.
He made some payment.
Just a second. Interesting. Show me where he made payments. Did you give him a receipt for payments?
No, this is a small town, and
It's not a small town, it's a family, sir. It's not a small...
I do have the ledger.
I'm not interested in a ledger you created. It's self-serving and therefore inadmissible and created for the purpose solely of this litigation and not created at the same time that the event took place. I might even cut you a little slack if you had a ledger, a book with entries in it at different times from 2017 in different ink, with a day, how much was paid back on the loan. I guarantee you do not have that. You have a very nice piece of white paper that you created for me. Is that correct? That is correct.
That is accurate.
Okay, so I'm not interested in your ledger. That's not a ledger. That's a document prepared for the purposes of litigation. So I want you to tell me what conversation you had and when with Mr. McDonald about paying for the truck.
Caption, coming up.
They bought this boat from you.
Accurate.
And how much did you sell it to them for?
$2,500.
Did they pay you for it?
No, part of that was put on the ledger, and part of it was cash.
You know I'm not buying your whole story.
A courthouse. The Judy Justice logo appears. In the courtroom, Herman, Tina, and Dalton.
Herman and Tina Smoody claim their former son-in-law, Dalton McDonald, owes for unpaid loans.
Now, I want you to tell me what conversation you had and when with Mr. McDonald about paying for the truck.
That was from the very beginning, because I was paying all their bills.
Just a second. I don't care whether you were paying their bills. I understand you were paying all their bills because they came to live with you for a brief period of time because they were evicted for whatever reason, and that was sometime in 2016. Okay. So I understand that you were paying their bills. Well, sometimes that's what parents do. They pay their bills.
We were paying their bills because they had no checking account.
That doesn't matter to me. I want to know your conversations with, where did it take place? Because you're not suing your daughter, you're suing him.
The conversation was when we rented the farm for them, which I know is not with the truck, but the landlord would not let them rent from them because they had terrible credit.
We'll get to the rent later. Stick with the truck. Don't talk to him when I'm asking him questions.
Well, the truck was the same thing. We put that on the ledger then, or on the running total, and they agreed. They both agreed that they were going to pay us off.
Okay.
He came over on Labor Day weekend, and I showed him the ledger, which he saw all the time.
No. Don't tell me what he saw. Don't tell me what he saw. If what you're saying is you showed him the ledger when he came over with the boys,
yes,
and he was going back to Minnesota.
Right.
And he brought the boys to see you to say goodbye?
Correct.
Okay, so far, it's very nice. You have a reasonable relationship with him, and certainly your daughter was clearly overwhelmed because courts do not usually split up children, so they must have felt that the children's best interest would be served if they remained with their father. Clearly what happened, the father came over to you to let you say goodbye to the children, and when he came over to let you say goodbye to the children, let me understand what you're saying to me. What you said to him was, not thank you for taking over this responsibility. Your daughter had more children than she could take care of, physically or financially, right? Clearly.
Yes.
Clearly. So what you want me to believe that two nice people who took in their daughter with her two kids and a husband and bought a truck and made arrangements for them to have some place to live, that these two nice people, when he came over, because your daughter couldn't take care of her children, and he brought them to say goodbye, you said, it's very nice. I want you to take a look at this ledger and see how much money you owe me. That's what you're asking me to believe, right? I'm going to let you live with that fantasy that I believe that.
And so I did give him the balance of what he owed me on the rent.
No.
And on the truck.
Nice.
And
he
he looked me in the eye, he shook my hand and said, Jerry, I promise I'm not going to screw you on this. I'm going to make those payments.
Make payments for what?
on the rent and on the truck.
Okay. Did you have that conversation with him?
No, I did not, Your Honor. The conversation was when I came up there the last time, Jerry was trying to sell his fishing boat, so I posted it on Facebook, and I sold it for him.
In what month and year?
That would have been September of 2020. After selling the boat, he gave me $1,200 for helping him.
How much did he sell the boat for?
It was $4,700.
So that was after you'd already moved?
Correct.
With the children?
Yep.
Okay. He helped you sell the boat for $4,700? Just answer my question.
No.
Did you give him $1,200?
No. He bought that boat from me a year prior to that. He had it.
So they bought this boat from you.
Accurate.
When?
That would have been in the spring of 2019.
And how much did you sell it to them for?
$2,500.
Did they pay you for it?
No, part of that was put on the ledger, and part of it was cash.
You know, I'm not buying your whole story. I'm not buying your whole story because what
Your Honor, I'm telling you the honest to God truth.
No, I don't think so. I don't think that I would have sold people who had no credit, who couldn't buy themselves a truck. So you had to co-sign for the only means of transportation that they had, who couldn't pay for their rent, who couldn't pay their bills because of their bad credit. I don't believe this whole scenario about selling them a leisure boat for $2,500. It's mind-boggling that you would think that an intelligent person like me would accept that. Okay, forget the truck. You have the truck now.
Yes.
Okay. You haven't finished your story with me, so you sold the boat, and he gave you $1,200.
Correct. I gave him the $1,200 back, which made us even on the truck payment, and he gave me the title. Tina signed it, and then I brought it back to Minnesota and put it in my name.
Okay. Who signed it?
Tina signed it.
My name was on it as well.
Your name?
Yes.
As joint owners with him?
Yep.
Co-signer.
Oh, interesting. In what month did Mrs. Smoody?
Yes.
Sign over the car to you?
The same day that I gave Jerry the $1,200, that would have been in September.
Now, do you remember the $1,200?
No, it was $1,000 that he paid toward the loan when I sold the boat for him.
Okay.
And it was his boat that I sold for him.
Okay. You did not create this as a marital debt. It absolutely was a marital debt. So I'm dismissing that portion of your claim that deals with the truck. Now, let's deal with the rent. The rent that you're talking about was rent in what property?
The farmhouse that they rented.
From when to when?
2016, November 2020.
And over the years that they lived there as a couple.
Yes.
The rent was paid to a landlord.
Correct.
By you.
Yes.
Is that right?
Correct.
And they, your daughter and her husband, would give you cash, checks, or whatever to cover the rent.
Yep.
Yes.
And how much did they give you to cover the rent?
When we started out, rent was $800, and later on he raised it to $900. We never made it a set amount each week. They gave us what they could. And we've done this before in the past, and they've always paid us back.
Well, then you should have sued them and listed all of this as a marital debt in the process of their divorce. So it could all have been...
We're handling Jacqueline in another way.
You what?
We're handling Jacqueline alone.
I don't understand what that means.
Well, you're saying it was marital.
Just a second. Does that mean that you've already served your daughter with a summons?
Not yet, no.
Of course not. Of course not. And you did know when they were divorcing. Yeah. You did know when they were divorcing. I'm not buying anything of this lawsuit, most of which, at least the rent part, is totally stale. I'm just curious, Mr. and Mrs. Smoody, somebody wants to answer this question for me. Mr. McDonald has custody of your two young grandsons, who I assume that you were close to because they lived with you in your house. And you seem like
live with us. The two boys came back to live with us.
From when to when?
December of 2021 until July of 2022. 6 months we had them.
Just a second, 2022. Was there a court proceeding?
No.
But then in July, they went back with their father.
That's accurate.
And they've been with their father since?
Yes.
Okay, so the boys lived with you for 6, 7 months.
Right.
Was that an acrimonious transfer?
Caption coming up.
That's what you meant when you said, any employer that has gone through all that paperwork and red tape, as I have, will do anything to avoid it. The anything is firing the employee.
A courthouse. The Judy Justice logo appears. In the courtroom, Herman, Tina, and Dalton.
Herman and Tina Smoody are accusing their former son-in-law, Dalton McDonald, of refusing to pay back loans.
Was that an acrimonious transfer, or was it something that you both...
What happened there was he called my husband to see if
No, don't tell me what he said to your husband.
Okay,
I will tell you then. He called me in December and asked me if I would please take the 2 boys. I told him, I will take them, Dalton, if you start making regular payments.
Oh, well, we're out of the money business now, sir. What you're saying is from 2017, when the children were in his custody, your daughter may have been there, but they were in joint custody, and then he maintained custody of the children, and during the time he maintained custody of the children, there was no question whatsoever that he was not paying you back money. He did not make any payments to you. Occasional here and there, we don't keep records. All of a sudden, now you have the boys with you, and then in July, he comes back and he takes the boys back. All I asked you was whether that was an acrimonious, which is an unpleasant, or a harmonious transfer of the children. Mr. Smoody was in July.
In July, it was acrimonious because at that point, he'd gotten a restraining order against me.
Against you?
Against me while we had the children. Because I sent him a letter saying that I wanted payment, and he went and got a restraining order against me because they took that as a threat.
I'd like to see the letter, please, Kevin.
Herman hands a document to Kevin, who brings it to Judy. She reviews it.
And this is what needs to happen moving forward.
That's correct.
You need to mail me $200 on the 1st of every month and $200 on the 15th, starting March 1st, 2022. If I do not get these payments on time, the following will happen, which is, you could say, I'm going to sue you, right? I'm going to sue you, but that's not what you say. You say, I will go to your boss and talk to them about garnishing your wages. Any employer that has gone through all the paperwork and red tape as I have will do anything to avoid it. So that's a threat. What you're saying is, I'm going to call your boss and tell him that I'm going to sue you, and then your boss is going to have to go through all the red tape of what it means to have a garnish on your salary. You have to go through accounting, and they have to deduct it. And no boss wants to do that, which is in effect say, so either you pay me or your boss is going to fire you. That's what you meant when you said, any employer that has gone through all that paperwork and red tape, as I have, will do anything to avoid it. The anything is firing the employee. The only thing that...
You can legally fire somebody.
Just a second. Whether you can legally fire them or not, that's what you were threatening. That's what that said. So we got an order of protection against you.
Correct.
And?
Then I didn't fight it because I didn't anticipate having any conversations or contact with him.
When you wrote this letter...
Yes.
You had the boys.
Yes.
Right. Not before.
No.
Not before. And he had the boys for some time alone.
3 months.
He had the boys for some time alone. Okay. Let's go back to my original question, which was, when the boys went back to their father, was it acrimonious or harmonious?
It was not good.
Well, so tell me your version of what happened.
The reason it was acrimonious is because he knew very well that once we got him, we put him on a strict schedule. 8 o'clock, brush your teeth, 8:15, pajamas, 8:30, bed.
Where was your daughter living at this time?
With us.
Yeah, just to say, if you're going to interrupt him because you want to get it out,
I'm sorry.
That's not going to be good for you.
She had a room at our house.
Just a second. So your daughter was living with you. So what you're telling me was your daughter was in the wind someplace.
Accurate.
Okay. You had her for a long time. He only had her for 5 years. And I can understand the sadness if your daughter is in the wind and not being responsible, sir. But that doesn't mean he has to shoulder all the burden. Right now, he's shouldering all the burden of supporting the 2 children, which I assume you're doing. They're living with you. And so are you working?
Yes, I am.
And he's working. Your daughter is not.
She's working 2 jobs.
She always has.
If she's working 2 jobs, why was she in a room?
She wasn't renting. She was living there free.
Okay. So now let's get back to this acrimonious transfer by the children back in July.
Dalton called me, or called the kids.
Okay, so he called the children.
After bedtime.
Okay.
Called my wife's phone 4 times. Ring, 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 ring. And she wouldn't answer because kids were in bed. And then he called my phone twice the second time. I have an old flip phone. I flipped it, walked in, because now I hear the boys are awake. I let them talk to the boys. And then I took the phone back and I said some naughty things to him and hung it up.
What did you say naughty things to him for?
Because I was very angry at him. Can I use some swear words that I used when I told him?
No, I assume you used some terrible words.
Yeah,
but
I just told him, don't call me anymore.
Is there any reason that you discussed with your wife why she didn't answer the phone?
Because the boys were already in bed. He had done that before.
You already told me that you heard the boys, so you took the phone into his room.
After the phone calls, they woke up.
Is what you're telling me that the first time that he tried to talk to the boys, that you or your wife didn't answer the phone?
I think it probably happened once or twice prior, and then we told him, don't do it anymore.
Okay, fine.
And this time we were fed up.
Fine. So that's when he said, I'm coming to take the boys.
No, no.
Well, when did he say he was coming to take the boys?
Not until July. Jacqueline told us that Dalton was going to be taking the kids once they got out of school.
Okay, I'm going to take the pain out of this case, and I'm going to do it relatively quickly. I think, Mr. and Mrs. Smoody, that this lawsuit was very ill-advised. The defendant doesn't owe you any money. He doesn't owe you any money because if there was money owed, it was a marital debt, and it should have been taken up at the time of the divorce, listed as a marital debt, and then it could have been fixed by the judge who approved the divorce how much and by whom is owed money. You chose not to do that. It was only after a very acrimonious set of circumstances, roughly 5.5 years later, after this truck was purchased, that you chose to exercise any prerogatives with regard to a debt, except this letter, which threatens to go to his boss to get him fired if you don't stop making payments, and that was only after the 2 children came to live with you and were sort of overwhelmed. You have to understand, Mr. McDonald, who I think probably is trying, he's got the 2 boys. It got very complicated, but it's not a lawsuit, and I would make nice with him. He's got 2 children that you probably want to have some connection with, and this lawsuit certainly doesn't help that. Well, anyway, for all the reasons that I've stated, your lawsuit's dismissed. We're finished. Thank you.
This court is adjourned.
Herman.
He owes us that money. He admitted he owed us the money.
I think the judge was absolutely correct.
He promised he was going to pay us the money back.
I don't owe Jerry any money.
Kids are irresponsible, have no sense of honor, duty, respect, responsibility, nothing.
It really should be a family thing, and maybe one day it can go back to it.
This was a great case that explains why a lot of cases in civil court have a statute of limitations before you can bring a certain kind of case, because here it was hard for us to understand why they would not have requested that money back earlier. So when you ask for it now, years down the line where so much has happened, court's not so likely to feed into that because you don't know what the real motivation is behind it.
I agree. I think it's really foolish of them, especially since their ex-son-in-law has total custody of these 2 little boys, for them not to maintain reasonable relationship with him.
It was a good showing, though, that if you do give money to your daughter, son, and their significant other, and they do get divorced, you should follow that divorce proceeding. So if you do have a claim,
a legitimate debt
or claim, then
listed,
that's the place where you should bring it.
Absolutely.
Title: Judy Justice.
Are you having a family dispute? Go to judyjustice.tv.
Did you claim that your daughter was being physically abused by her father? That's either a yes or a no.
To a point.
I really don't understand 2 people who hate each other more than they love their child. Period.
This is
Curtis Brown and Heather Palin are suing Heather's ex-husband, Scott Manis, for impound fees, harassment, and defamation.
Court come to order. All rise.
Have a seat, please.
Kevin approaches the bench.
Case 2142, Brown, Palin versus Mannings.
Thank you.
You're welcome.
Miss Palin, this is your former husband.
That is correct, Your Honor.
How long were you married?
18 years.
And this is your daughter?
Correct.
Is this your only child?
With Mr. Manis, it is.
Yes.
Yes.
You have other children?
1 other, yes.
How old?
32.
When did you and Mr. Manis separate?
I moved out of the family home in March of 2018.
And this is your boyfriend?
Correct.
I'm going to, in broad strokes, at least try to reconcile both the complaint and the answer in this case. I assume there was a time when your daughter, whose first name is? Trisha was living with you after the separation.
We had a mutual divorce decree of 50-50.
And was that honored?
Until September 4th of 2020, Mr. Manis had brought Trisha back to my home. And while we were out of the home, he had her pack her belongings.
No, okay. Let's stop there. Trisha, how old are you?
I'm 19, Your Honor.
Right subsequent to the separation and the divorce, until September of 2020, you shared custody.
Correct.
Yes, ma'am.
And then Trisha decided she would prefer to live with her father.
Correct.
For whatever reason. I don't have to go into it, because this doesn't really have to do with who she chose to live with or where she was living. It has to do with a car. Okay. So while she was living with Mr. Manis purchased a car.
Yes, ma'am.
For her use.
Correct.
In what month did you purchase a car for her use? Month and year?
Oh boy, I believe that was probably February of 2019, I believe. 18 or 19.
Well, let's figure it out.
It was about 6 months prior to the case with her. So September 4th, we had the car. It would have been probably June or July of the same year.
So you bought her a car a couple of months before she decided to come and live with you?
Correct.
Okay, I got it.
She had just obtained her driver's license.
That's okay. I'm just trying to get a timetable. Right before she decided to come to live with you and not have 50-50 custody anymore, you purchased a car for her.
Correct.
And she drove that car in June or July, August?
Correct.
At your house?
At both houses.
She was allowed to go to take the car to their house?
Correct.
When she saw her mother?
Yes.
And then bring it back?
Correct.
There was a time when you took the car away from her. When was that?
Probably mid-August.
Mid-August of 2020?
Correct. Well, the threat was to take the car away because her grades were slipping. I didn't actually take the car away.
When did you take it away?
I actually never did take it away. Her mother and her mother's boyfriend decided to purchase her another car to eliminate my threat of taking away the car.
Well, I don't know if that's because, but they decided to
Correct.
purchase another car. And what did you do with the car that you had gotten for your daughter?
I sold that.
When did you sell it?
Probably a month or so after she got the other car.
And the threat was made to your daughter because you were concerned about how she was doing in school or how she was doing socially. What were the reasons?
Well, her grades were slipping. Okay. So I wanted her to concentrate more on her grades rather than...
Grades were slipping?
Correct, at school.
Did she give you any reason for that?
She was under a lot of pressure with the divorce.
So you purchased a car, Mr. Brown and Ms. Palin, with the understanding, according to your complaint, that the car would remain in your name. There would be payments made on the car, and once the car was paid, it would transfer to Trisha. Well, one thing led to another. Things sort of went south. And according to what I've read in these papers, you got sort of annoyed. And the car that you had purchased was in the physical custody of Trisha, who was living with her father. And Mr. Manis caused the car to be towed and impounded, which caused you substantial expense to get the car out of impound. And he did that maliciously.
Correct.
And you want him to pay those expenses because you did, in fact, get the car out of impound, subsequently sold it. How much were the impound fees?
$1,565.22, Your Honor.
Okay. And Mr. Manis, in defense of that, acknowledges that he towed the car, your car. He towed the car, which was at your house?
Your Honor, I had
Where was the car?
The car at the time was at my house.
That's what I'm asking you. The car was at your house. You had it towed to impound. And you had it towed on what date, sir?
The car was impounded on September 4th.
Of what year?
2020, I believe.
And your defense for doing that?
Your Honor, he requested...
Just a second. Your defense for doing that is that you were merely following Mr. Brown's instructions.
And the police officers.
You were following Mr. Brown's instructions.
Correct.
Yes, you have a police officer here.
I have several police reports, Your Honor.
About what?
This isn't just about the car. There's several years of harassment.
No, I'm dealing with the car.
I understand.
Right now, I'm dealing with the car.
So I have the several officers that came, instructed us to get the car removed from the property.
Well, that may be, sir. You can have the car removed from the property and ask the police to have it deposited in front of their house.
I understand.
Yeah, you chose not to do that.
May I show you his request to have the car towed? He offered a reward for the car to be towed.
Just a second. I want you to tell me where I'm wrong so far.
Scott grins and shakes his head. Caption coming up.
See, what we can all do to make her as unhappy as possible. So I really don't understand two people who probably, in their own way, love their child, but hate each other more than they love their child, which to me is absolutely bizarre.
Scott shakes his head. A courthouse. The Judy Justice logo appears. In the courtroom, Curtis, Heather, and Scott.
Curtis Brown and Heather Palin claim Heather's ex-husband, Scott Manis, owes for impound fees. Scott is countersuing Heather for filing a false CPS report.
Okay. You had the car towed to an impound. You did not call him or your ex-wife the day that you had the car towed to impound. It was some period of time later, if the fees for impound were $1,500. Your excuse for that is you were merely following his request. His request. That's what you wrote in your answer. Is that wrong?
No, Your Honor.
Okay. Well, so now we know that you didn't notify them when you had the car towed.
Your Honor.
Because you could have had the car towed to the local police precinct and called them and said, come pick up the car. It can't be in front of my house anymore.
Your Honor,
He was actually at my house that night.
Just a second. I didn't ask you anything.
Sorry.
Go ahead.
the police, when they came to our house, the car was present. They acknowledged the presence of the car.
You can't tell me what the police did, sir.
I have the reports, Your Honor.
I'd like to see, I will see the report. What I'm asking you is, there are two things. If you wanted the car out of your custody and you wanted to quietly and stop the friction, send it back to the people who purchased it, you could have done that. You chose not to do that.
Your Honor, the reason I chose not to do that is because of I have several false allegations from CPS, the police. I did not choose to have any contact
You
with
don't
them
have to have any contact with them, sir.
in order to.
You don't
get in
have
the
to have
car.
any contact with them. Just like you paid a tow truck company to take the car to impound, you pay the tow truck company, you live in a private house or an apartment.
Private house.
You have the tow truck company drop the car off in front of their house. Now, after you had the car towed to an impound company, did you contact them in any way?
No, I didn't.
No.
I was instructed.
Did you
not
ask
to
the
by
police to contact them and tell them?
The police knew, yes.
I didn't ask you what the police knew. You can't tell me what the police knew. So you had the car towed on September the 4th. And when were you notified the car was in impound?
I received certified letter on September 26th, which was a Friday. It said to contact them Monday through Friday between 8 and 4.
Just a second. You received that on September 26th.
Yes.
Is that the first notice that you had that the car was impounded?
Correct.
Yeah, that's the
Okay. So now the onus is upon you, Mr. Manis. I want you to prove your defense to me, and your defense was you were following Mr. Brown's instructions.
Yes, Your Honor.
Okay. That's all I want to see.
Here you go, Your Honor.
Scott hands a document to Kevin, who brings it to Judy. She reviews it.
So this says $100 reward to anyone that impounds my car. Call a tow truck and tell them to contact me.
Yes, Your
You
Honor.
know this number.
Yes.
Yes. Well, did you do that?
The tow company sent them a letter on 9/10 of 2020, and I have the proof of that also, Your Honor.
Yeah, I would like to see what you're looking at. That's not on September 4th.
No.
That's not on September 4th.
9/10, they sent that out,
Okay.
the notice.
Let's see.
Judy reviews another document.
Well, this says that attempts were made on 9/21, 9/26, and 10/5. That's what it looks like, attempts made.
That's when they had attempted to deliver, but they did not pick it up.
So they had no notice.
They had notice.
No,
did
they
not
had
pick
no
up
notice.
They
They
didn't pick
had
it up.
no notice.
If they would have gone to their post office box, they would have had notice.
If I had taller parents, I would have been 5'7".
Heather grins.
They had no notice. Okay, $1,565. That's what you owe them. It was a malicious act.
Your Honor, this isn't just about the car.
This
There
is
are
all.
horrendous
Listen to me.
False
This is
allegations
all.
through CPS. If you would please.
Let me. You have a counterclaim.
Yes, ma'am.
And your counterclaim I'm going to hear. Right now, you owe Mr. Brown $1,565 because what you did was malicious. And I don't understand something. You have one child together. I assume that you don't want to make her miserable. That when she was born, you said, oh, let's see what we can do over her lifetime to make her as unhappy as possible. Let's see what we can all do to make her as unhappy as possible. So I really don't understand two people who probably, in their own way, love their child, but hate each other more than they love their child, which to me is absolutely bizarre. So right now, because you did a malicious thing by having their car towed and not giving them a heads up that you had the car towed to a place that was going to cost them money, you owe them $1,565. Now I'm going to hear your claim that they made false charges to CPS about you.
Yes, ma'am.
Your Honor,
Oh.
can I say something?
About what?
The car.
Before you say anything, did I say anything that was inaccurate? Did your father have the car towed? The answer is he's acknowledged that. He had the car towed and put it in a place where neither your mother or her boyfriend knew where it was, resulting in their having to pay fines to get the car out. Is there anything that I said was wrong?
That is partially incorrect because I had contacted my mother in the time and asked either.
Okay, that I'll hear. You contacted your mother.
I did contact my mother previously, not only on normal messages, but also on messenger messages, including how I wanted either the title or my money back and that they could have the car before that. Once the Facebook post was...
All I want you to show me is that you notified either your mother or Mr. Brown that the car was impounded when you notified them.
She also did ask my best friend where it was.
All I want, that's all I want. Don't tell me what you said to your best friend who's not here. All I want to do is see where you notified your mother that the car was impounded.
So there is this one about money in my account, which was about the car.
I don't want to see anything about the car. I only want to see where you notified your mother or Mr. Brown that the car was impounded.
Okay. I don't have the text about that, but I did notify her that it was impounded.
Well, I don't know that, and it seems to me you weren't talking to your mother on a regular basis because there was a lot of acrimony. If you have it, you have it. If you don't have it, you don't have it. So, Tricia, you could sit down.
Tricia sits. Caption coming up.
I'm telling you that it is inappropriate, the act of sharing a bed with a teenage female child as a father would give me cause to pause.
Scott shakes his head. A courthouse. The Judy Justice logo appears. In the courtroom, Curtis, Heather, and Scott.
Defendant Scott Manis has accused his ex-wife, Heather Palin, of filing a false report with Child Protective Services.
Now, it was a malicious act to have the car impounded. There's no question in my mind that if they knew it was impounded, they would have gotten it out before. $1,565. Now, you want to show me what information you have with regard to filing a false CPS report.
Correct. I have the CPS reports and the police investigators report.
Okay, may I see it, please?
Scott hands a document to Kevin, who brings it to Judy. She reviews it.
This report, it was in September of 2020.
Yes, ma'am.
Okay.
It's been several years of these reports and
Just
the disgusting allegations.
So you filed or you made allegations to Child Protective Services?
CPS actually contacted me, Your Honor, regarding several calls that they had received for the welfare of my daughter, Tricia.
In what year?
I was contacted, I believe it was 2019, and again in 2020.
They contacted you?
Correct.
For what?
To do an interview because of a claim that was made regarding Tricia's safety.
That were made by an anonymous source?
I don't know who made them, Your Honor. In Minnesota, you can't make multiple reports by one person. I cannot call day after day to make reports.
I'm just asking you, did you at some point claim that you had reason to believe that your daughter was being in some way physically abused by her father? That's either a yes or a no.
Yes, to a point.
Yeah, okay. And part of that involved a sexual abuse.
That one was not claimed by me. I did state to CPS that he does have her sleep in his bed with him.
Well, I have to tell you
which
something.
Is a little
I
weird.
have to tell you something. That doesn't seem a little weird. It seems a lot weird that your daughter acknowledged, sir.
Your Honor?
Your daughter. What I'm telling you is, it is inappropriate for a man to sleep in the same bed as his 15-year-old daughter.
Your Honor,
that's
we went
my
to a
view.
concert.
And if that's true, there may be a reasonable explanation for it. She said she was scared, whatever, but when interviewed, that's what it says in here. But I'm telling you, as a mother and a grandmother, in my view, and I'm not a professional psychiatrist or psychologist, but it is inappropriate for a teenager to sleep in the same bed with her father. Period.
Scott shakes his head.
Maybe some countries it's appropriate, but
Your Honor, we went to a concert.
What?
And shared a hotel room at a...
No, that's not what your daughter said. No. That's not what your daughter said, sir.
May I finish?
Yes.
When she was going through all the stuff with the divorce and everything, she came into my room. I was asleep. She laid next to me. I'm asleep.
Listen to me. I'm not suggesting
Your Honor,
that
there's
anything
nothing
inappropriate. Sir,
absolutely right.
understand this. I'm not suggesting that any inappropriate actions happen between you and your daughter. I'm telling you that it is inappropriate, the act of sharing a bed with a teenage female child. As a father, would give me cause to pause. I would say, you know what? That's not a good idea. It's especially, sweetheart, it's especially not a good idea when parents seem to be feuding. It's grist for the mill. You may want to go and, if she's scared, say, sweetheart, I'll go and sit in a chair in your room.
Many times.
In your room.
Many times.
But please, this is inappropriate. Do you understand? It's inappropriate.
Did you read the detective's statements in there?
No, I'm not interested in the detective statements. sir.
Obviously.
If what your daughter says is true as a result of the investigation, then there was reason for somebody to suggest to CPS to do an investigation. So listen, bottom line, I can't tell the two of you to stop feuding. I can't. You either hate each other more than you love your daughter. That's the answer. And this court can't fix that. All I can do is fix $1,565, which is what you owe them for impound fees. This case is over. Thank you.
This court is adjourned.
Outside the courtroom, Scott, then Heather.
I think the judge is wrong.
I am thankful for the judge.
She didn't read all the evidence. Multiple pages weren't read.
He's very good at manipulating others
And multiple accusations.
and being the person that, pity me, feel sorry for me.
False allegations to the CPS.
My ex-husband decided that he would show me.
No, I was trying to get my daughter her money back or the title to her car.
He actually had the car as of August 24th. Then he brought her to the house and moved her out on September 4th. And that's when it just started going downhill.
She has a lot of hatred.
I believe he's very angry that I divorced him.
That she falls off a bridge.
And he lost the control over me that he had while we were married.
Judy and Sarah.
You know, Sarah, I've been doing these family cases for probably 40 plus years. And it always makes me sad that the mother, the father, even the new boyfriend, there is a window in life when you feel relatively healthy, nothing hurts you, you don't have a bad back, you don't have to worry about indigestion, you can walk around without a walker, you look pretty reasonable, and that you will take years away from that good time to create negativity around not only yourself, but the people that you love.
I think that's great advice.
I always said to people, both men and women, that, it's one journey. You can take that journey and put as much positive energy into it.
Yeah, I just felt bad for the daughter. I mean, I know she's grown now, 19, but still 19, it still hurts your feelings to hear and see that your parents hate each other more than they care and love about you.
Well, maybe that statement
will make a difference. You never
will
know.
make a difference, because I'm sure it's not true.
Yeah.
I have a feeling.
But when it's said to you in a court in front of your child, hopefully they take some action on it then.
Well, hopefully they'll say, boing, I mean, she has a new boyfriend, and he's got his daughter who's living with him. They should be happy.
Yeah.
And they're divorced.
Close the book and move on.
Close the book.
Yeah.
Her mother and her boyfriend should get a puppy together. Well, they should,
Not
not
until
until
they
they
get
got married. Not until they, but do something. This is a grown young woman.
Have a healthy
Should they-
adult relationship with
Ship
your adult
grown
child.
Right, not over a car. But you know, teenagers do crazy things for a car. I think that some teenagers would live with Satan if they bought them a car.
Title, Judy Justice.
Are you having a family dispute? Go to Judy Justice.
Your truck hit his air conditioning unit. Did you see who was driving the truck?
The young lady beside him.
Somebody was driving the truck.
My son.
I don't know why you would say my son was driving unless she doesn't have a driver's license. You have a driver's license?
I do not.
There you go.
This is Judy Justice.
Rome.
Robert Ritter is suing homeowners Jeff McNally and Angela Klingenberg for property damage.
Court come to order. All rise.
Judge Judy.
Have a seat, please.
Kevin.
Hello, Judge. Case 2164, Ritter versus McNally Klingenberg.
Thank you.
You're welcome.
Judy turns to Robert.
Mr. Ritter, you own a piece of property,
That is correct, Your Honor.
and it's a residential piece of property,
That is correct.
and you use it as a business.
That is correct.
I would assume that this is your tenant.
That is correct.
Perfect. Could you stand up next to Mr. Ritter? What is your last name?
Mason?
Mason. These are your neighbors across the street?
Yes.
I live side by side.
So you're side by side, not across the street?
I live across the street.
Now, there came a time, Miss Mason, that you heard something that was unusual. Can you describe what you saw?
I was startled by the sound of a big thud and my dog freaking out and ran to the window. And so I jumped up, ran to the window where the dog as well was running toward, and looked out the window and seen the truck that had just hit the air conditioning unit.
Can you describe the truck?
A white truck pickup.
Had you seen that car before?
Yes, in the driveway next door to me.
So in his driveway?
Yes.
Did you see who was driving the truck?
I did.
Was it Mr. McNally?
It was not.
Who was it?
The young lady beside him, friend
Miss
across the street.
Klingenberg?
Yes.
When you looked outside, what did you see the truck do next?
As I looked out the window and made eye contact, I seen...
With her?
Yes, I seen Jeff at the back end of the truck, right by the AC unit, kind of backing her off a little bit, kind of gave her a raised hand.
So he was out there as well?
Yes, positioned behind the truck.
What did you do?
Well, I jumped up and then I ran and actually grabbed my phone to take pictures because I did not want to be responsible for what had just happened to the air conditioning unit. As I could tell, it had been moved and hit.
Do you have those photographs?
I did send those to Bob. He has pictures of those.
Kevin?
Yes.
Want to get them?
I immediately text Bob as well, letting him know.
So that day, the 20th of August, you went, took photographs of the truck?
Yes, ma'am, and the yard and the air conditioning unit.
Okay.
Robert hands photos to Kevin, who brings them to Judy. She reviews an image of a bent air conditioner grill.
Mr. McNally,
Yes, Your Honor.
where had you been camping?
We were camping in a place called McCall, Idaho.
Aside from you and Miss Klingenberg, who were there?
My son.
See how easy this is? It's going to get easier. Do you understand?
Jeffrey grins.
Okay. Now, is this your girlfriend?
Yes.
Okay. Now we got that clear. This is your girlfriend. You and your girlfriend were camping. Your son was with you. And what you were doing that day was you were trying to unload the truck with the camping gear, correct?
Correct.
Is the camping gear heavy?
Yes.
So somebody was driving the truck and somebody was schlepping the stuff out of the truck to put it away, right?
Correct.
Now, Mr. McNally, you don't want me to believe that either you or stand up, or this guy were just twiddling your thumbs and you backed up the truck so that you left Miss Klingenberg to empty the truck, right? You don't want me to believe that.
No.
Because that wouldn't be true, and that would be foolish, and that would make you certainly unchivalrous, right?
Correct, Your Honor.
Okay. So when you were first confronted with this, you said, oh, my girlfriend wasn't driving, right?
Right.
So let's get it straight now, because that's what you wrote here in your answer. Oh, my girlfriend wasn't driving, my son was driving. That's not true. I don't know why you would choose to say my son was driving, not my girlfriend, unless she doesn't have a driver's license, because otherwise there'd be no difference whether your truck was being driven by you or your son or your girlfriend. Do you understand? No difference. Your truck being driven with you around hit his air conditioning unit. So what difference does it make? You have a driver's license?
I do not.
There you go. Perfect.
I was not driving, Your Honor.
Yes, you were. Yes, you were. You were driving, and he says you were. You see, and he says you, just a second. You didn't see his face just now. He says you were. Now, how did I know you didn't have a driver's license? Do you have a driver's license?
Yes.
Yes. But how did I know you didn't? Where do you think I got that from? I got that from common sense, because Mr. McNally doesn't look like a stupid man. And there would be really no difference if he drove the car, you drove the car, the son drove the car, his car caused damage. But in order to perhaps have insurance cover it, if he had insurance on the truck, do you?
My insurance had actually lapsed.
What? Okay, so it really didn't make any difference. If you had no insurance, you could have said she was driving. But didn't think that far. Okay, so that's why we're here. We're here because you let an unlicensed driver drive your truck that was uninsured that you took on a camping trip. Is this coming together for me?
It's close.
So now we got that straight, right? The next thing we have to take care of are the damages. I see that the outer part of this air conditioning unit was definitely hit. Now, the outside is merely a cover. So I need some evidence that this damage that he caused while she was driving damaged the mechanism of the air conditioner, because you replaced the unit and you want him to be responsible for the unit, right?
That is correct, Your Honor.
I have to see a photograph, because I don't have this photograph of the inside of this. I just have the photograph of the cover.
I do not have the inside, but I do have from 2 HVAC companies that did go out to service it. One that did the replacement, the other that came out second opinion, as Jeff had asked us to do, which we did.
Okay, I'd like to see it.
This will be the second, and this is the actual invoice for payment.
Kevin collects documents from Robert, then brings them to Judy. She reviews them.
Oh, this is the second opinion. This says, second opinion call, 4-year-old Goodman air conditioning unit has been backed into. The unit has permanent damage to the condenser coil. Oh, well, that's the unit itself. That's just not the lipstick on it. That's the guts of it. This says immediate repair, replace condenser coil and damaged panels, 3961.
Correct.
Replacing the unit instead may be an option to consider. And to do the whole job, what did he want, $5,000?
The other side, $34.50 to replace the identical unit.
Okay, and to repair
it was less money to replace
than
it.
to repair.
Correct.
Okay. Do you understand that now?
I do.
Okay.
Thank you, Your
So,
Honor.
based upon your request, he got a second opinion. Second opinion was for more money to repair. He chose the lesser of the two, which is to replace the unit. The ball is in your court, sir.
Jeffrey closes his eyes. Caption, coming up.
Garrett was actually driving.
I don't believe it. You've had some time to reprocess it all. You would have had the boy, that's what you raised them for, strong boys. You wouldn't have said, well, you just sit in the car while my girlfriend unloads it. Take the hair out of your eyes so I can see your eyes. Perfect.
And later today.
I want to know how much you received from the insurance company.
$874.53.
Then can you tell me, I had a check from the insurance company, which was a little over $1,300 from their appraisal.
No, that's incorrect.
Well, that's what you wrote, madam. That's your signature, that's what you wrote.
A woman shrugs. The courthouse. The Judy Justice logo appears. In the courtroom, Robert, Jeffrey, and Angela.
Robert Ritter claims homeowners Jeff McNally and Angela Klingenberg owe for property damage after hitting his air conditioner.
Your car, uninsured as it was, driven by your girlfriend, damaged his property. Why don't you think that you're responsible for it?
We don't believe we hit it.
The damage is on your truck, sir. There's a picture of your truck here. You want to see it? Or you don't have to see it. You'd be better off just saying, you know what? I don't have the money. You'd be better off just saying, because we started out wrong, you and I, Mr. McNally. And the wrong started off was claimed his son was driving, even though Regina clearly saw his girlfriend. Okay, so that was a fib here.
Actually, Your Honor, if you If I may, there was just one front seat, a bench seat, and she was sitting in the middle, and Garrett was actually driving.
I don't believe it, sir. You've had some time to reprocess it all. That's not true. She was driving because if you were unloading the truck, you would have had the boy. That's what you raised them for, strong boys. You wouldn't have said, oh, you just sit in the car while my girlfriend unloads it. You wouldn't have said that. Put your hand down. Take the hair out of your eyes so I can see your eyes. Perfect. Thank you. Judgment for the plaintiff in the amount of $3,800. It's not a good idea, Mr. McNally, to show your son that it's the right thing to do, not to tell the truth. That's a very good lesson that parents should teach their children right from the get-go. And accepting responsibility for what was clearly an accident. I mean, she didn't mean to back into his air conditioner, right?
Right.
It happened. It was an accident. That's why they don't call it an on purpose. It was an accident. But once you have an accident, you have to accept responsibility. That's what you want to teach him. And if he lifts his hair, he'll be able to see and be able to hear better. We're done. Thank you.
This court is adjourned.
Outside the courtroom, Angela, then Regina.
We were all sitting in the front of the bench seat, so I was in the middle, and I think when she initially came out, she saw me sitting in the truck, but maybe she assumed I was sitting in the driver's seat, but I wasn't.
Nope, my vision was great that day. It did make me jump, and my dog was freaking out, so I definitely knew something hit the house.
I told him that my son and I were emptying firewood and that he may have hit his AC unit.
It's just sad, you know, that they had to do that and that the young man had to be involved when he really didn't do it.
Sarah and Judy.
That case was a great demonstration of how being well prepared and doing the right thing can make the justice system work for you in the right way. He had all of his evidence laid out exactly how he needed to present it to you, and he had the damage evidence, he had the photographs, and he did the right thing. He didn't try and get a whole new unit for the $5,000. He said, I'll get the 2 estimates if that's what you want me to do. So it just shows how being prepared and having all your ducks in a row can really benefit you when you come into a court system.
But my problem was telling the lie after you've sworn to tell the truth in front of his son, because those things remain embedded in your children. You want to be a good parent. The first thing you have to teach your children is to be honest. And if he sees that his father and the father's girlfriend are dishonest, that will become part of his fabric. Yeah. That's a mistake. So,
I agree.
But I think you are correct that it was a good lesson in preparing a case that made it easier to try.
True.
Kevin.
Case 2171, Cosby versus Warren. All parties, please step forward.
Shalea Cosby is suing mechanic Kevin Warren for the repair cost of a car and lost wages.
Okay, Miss Cosby. According to your complaint, you parked your car near your home on a side street. You came out the next day and you found your car vandalized. Car was a 2017 Hyundai Elantra.
Correct.
Did you buy the car new or used?
Used.
And how much did you pay for the car?
I put a down payment of $1,350, I believe, $1,350.
So you financed the whole thing?
Yes.
And you have to have insurance on your car. You have to have liability, collision, all that other good stuff because you have a loan.
Right.
And you did have insurance. Now, came out, you looked at your car and it was vandalized. What was wrong with it?
The back window was shattered, and along the side passenger top quarter panel, back passenger door, and the passenger mirror, it was shot.
You have photographs of it?
Yes.
I'd like to see it.
Right here.
Shalea hands a document to Kevin, who brings it to Judy. She reviews images of a damaged vehicle.
Okay. Did you notify your insurance company?
I did.
On what date?
The same exact date, which was July 22nd, is when I came out and found my car vandalized. I submitted a police report. I have that right here.
I'd like to take a look at it, please.
And
Kevin collects a document from Shalea, then brings it to Judy. She reviews it.
Okay, nothing with nothing. Okay, so you told the police about it on the 22nd.
Yes.
And when did you bring it in for the defendant to take a look at it?
That was August 18th.
She brought the car into you in August?
Yes.
And how long have you been in the auto repair business?
16 years.
So you've dealt with insurance adjusters before?
Yes.
And did you make the appointment for the insurance adjuster to come and look at the car?
They never came to look at it. Sometimes they just have me submit photos if they don't have anyone in the field to come look at the vehicle.
Okay. Now, when the plaintiff came in and brought you the car, did you have a discussion with her?
Yes, I did.
And I want you to tell me the best of your recollection what she told you and what you told her.
Okay, like she said, she brought me the vehicle on August 19th. And she told me she took it from another shop. She had a problem with another shop getting the repairs done.
Tell me what kind of problem you had with another shop.
It was no problems with the other shops besides they didn't want to do the estimate on it and told me to talk to my insurance about it. And my insurance told me to find my own shop. And that's when I found it.
Just a second. Did your insurance company send you to the first shop that you went to?
Yes.
And for some reason, that first body shop was unsatisfactory to you.
Mm-hmm.
So you took it to the defendant. This is what the story is. The story is the defendant still has your car, right?
Mm-hmm.
And he's keeping your car because he says you didn't pay for the repairs. It's your position that you gave him the entire check from the insurance company. Is that your position? Speak. Be very careful what you tell me.
Caption coming up.
This is how her car looked when she brought it to me.
Oh, Miss Cosby, I have a feeling that you're not going to like the outcome of this.
Oh, no, I'm legit all the way around.
Oh,
so
really?
Those are the afterward
Just
pictures.
a second. Hustler.
Oh, it's not a hustler at all, man.
Absolutely a hustle.
Shalea shakes her head. A courthouse. The Judy Justice logo appears. In the courtroom, Shalea and Kevin Warren.
Shalea Cosby claims mechanic Kevin Warren owes for the repair cost of a car and lost wages.
The insurance check went to you
Correct.
to cover the damage to the car.
Correct.
I'd like to see the check receipt that you received from the insurance company.
Shalea hands a document to Kevin, who brings it to Judy. She reviews it.
Look, we're going to have trouble with each other, madam. Do you understand? This isn't the only check you got from the insurance company.
If you're talking about a check in 2020, that has no relevance to 2022 vandalism check.
I want to know how much you received from the insurance company.
$874.53.
Then can you tell me, I had a check from the insurance company which was a little over $1,300 from their appraisal.
No, that's incorrect.
Well, that's what you wrote, madam. That's what you wrote. That's your signature, that's what you wrote.
I see the paper. The totaling was $1,374.53. I didn't receive a full $1,374.53 check from my insurance. I received $874.53 and had to pay my deductible of $500.
When you brought your car into Mr. Warren, tell me what the conversation was.
Before I got to him, I let him know what was going on and what I was going through.
No, not let him know. I asked you what you said to him and what he said to you. First of all, you didn't like the first place that the insurance company sent you to. I don't know why. All I know is when you're dealing with this kind of thing, everybody's trying to make a little bit extra. And it's been my experience, and maybe I'm wrong, that when you have a little accident, you take your car into a body shop. Very often, if that's their business, they say, this is what you want fixed, this is what the damage was. And the person who runs the body shop or the owner of the body shop will say to you, I'll take whatever the insurance is, I'll work with the adjuster. Mm-hmm. That's what they usually do. Correct, sir?
Yes.
Yes. And in this case, is that what happened?
No.
Is what I'm asking you. Because your complaint is that he has your car, won't give it back because he's put a mechanic's lien on it because he says that he did $6,000 worth of work on the car.
He did work that was not approved by me nor my insurance.
I'm just telling you, that's what he says. He did $6,000 worth of work on the car.
Okay.
Okay? But I have to tell you, Mr. Warren, that has been my experience, and I'm very old. That when you take a car in that's been in an accident, they say, you know what, I'll work with your insurance company. And we all know what that means. That means that whatever your insurance company gives you, they'll send me the check. That will be what I'm going to accept for the work. Now, what you're suggesting is that she authorized you to do $6,000 worth of work, and you didn't speak to the insurance company.
I spoke with them plenty of times.
Oh, what did they tell you that they were sending her?
I have it here.
I'd like to see it.
I have 3 estimates here.
No, I want to see from the insurance company.
They're the insurance company estimates, not mine.
I'd like to see it.
Okay, here's the first one. Like she said, when she first brought her car to me, she had this one already for $873. Okay, so then what we do when we see more damage, we put what you call a supplement in. So I put a supplement in, and that's when they told me she has 2 claims. She has a claim for the auto body damage and a claim for the vandalism. The $874 is for the vandalism. If you look at these other 2 estimates, it's a totally different claim number.
May I see it, please?
That she put the claim in for. So these other two are for the auto body portion.
Not for the vandalism.
No, it's two different claims.
When she brought you the car, was there body damage on the car?
Absolutely. This is how the car looked when she brought this to me.
I'm not just talking about that. Can I see, please?
This is how her car looked when she brought it to me.
Oh, Miss Cosby, I have a feeling that you're not going to like the outcome of this.
Oh, no, I'm legit all the way around.
Oh,
so
really?
And those are the afterwards
Just
pictures.
a second. Just a second. This car was in a bad accident.
Yes, correct.
This car was in a bad accident. Hey, this car was in a bad accident shortly after you got it.
Correct.
Right. And you got a check from the insurance company to fix this.
Correct.
How much was the check that you got from the insurance company to fix this?
The total in amount, I'm not sure, but I think it was like 2001 or 2002.
And you didn't have it fixed.
No one wanted to fix it.
Well, he fixed
So
it. Just a second. Hey, Miss Cosby, he fixed it.
Without
Just
my
a sec.
approval.
What did you do with the $2,000?
Oh, I paid my own personal bills because no one wanted to fix the car, so I have to keep living.
Your case is dismissed.
Okay.
How's that?
That's
Your
fine.
case. Hustler.
Oh, it's not a hustler at all, man.
Hustler. Absolutely, absolutely a hustle. I actually think you're a hustler. That's why I'm not helping you.
That's fine.
Because you had an accident in 2020, you got a check from the insurance company to fix it. I don't know how much that check was because you don't have a copy of that check. You brought the car into him and said, now I have a broken back window. I have a feeling, and I know it's only a feeling, but this is my program so I can vent that feeling, that you went to the first place to fix the car and you said to them, I want you to fix the front and the back, and they said no. That was for something else. You already got paid for that.
Incorrect. They
So you
didn't
went to
want to
him.
do an estimate altogether.
Yeah, I don't believe you.
You don't have to.
I don't. Well, I don't. I don't.
have to.
That's why your case is dismissed.
That's fine.
Now I'm getting to your counterclaim. Because you put a mechanic's lien on the car?
Yes, I have it here.
Great. So you've got a mechanic's lien on it. She can't sell it. I'm not giving it back to her. I'm not ordering it back to her. You have the car?
Yes.
Sell it.
I need that signature on that paper to be able to do so.
It doesn't matter.
From whom?
From her. Or you can sign it just to say.
Oh, I can't.
To turn over.
Oh.
That says she has no more interest in the car.
I can't. She does have an interest. The car's got a lien on it, sir.
Absolutely.
Okay? You're going to have to pay off this note. Do you understand? I don't think you're going to be able to get the money after you pay off the note. But you fixed the car.
Absolutely.
And I think that you're entitled to money for fixing the car on your counterclaim. She's going to pay on your counterclaim because I'm not sure whether you're going to be able to get any money on this car. I don't know what's going to happen with this car. I'm just not returning it to her. Do you understand?
Yeah.
I'm going to try to make you as close to whole as you can be because I think what happened to you was a hustle. That's what I think. Usually I don't side with mechanics. It's just been my experience. But I think that
I'm glad you changed today.
I think that this is a hustle. $3,800 judgment for the defendant on the counterclaim. Thank you very much. We're done.
Outside the courtroom, Kevin Warren.
Oh, I appreciate her decision. I believe she ruled the right decision because I brought all my paperwork and it wasn't no other way to rule it. Well, she said she wanted me to help her get her car fixed and that she was gonna get the insurance and pay me like she was supposed to do, but I guess once she got the money, she changed her mind. All mechanics aren't bad.
Judy and Sarah.
That was a surprise.
That was.
For me.
Did not think it was going to go that way when we reviewed it
When
earlier.
we talked about it, I looked at it. When we spoke about it, I said, you know, sort of using my life's history. Take the car in, don't worry, I'll work with the insurance company, does a little bit more work. The insurance company sends a check for a little less. But he wasn't at fault. She was the hustler.
Yeah, he wasn't trying to make an extra quick buck like a lot of mechanics that we've seen. He did the work.
He did the work. Because she didn't bring the car in there just for the back windshield.
Mm-hmm.
It's a hustle.
It seemed that way. As soon as somebody says, oh, that thing from then has nothing to do with why we're here now, immediate red flag.
Bing, bing.
Yeah.
Anyway, I'm glad that worked out. And
me too. I'm glad you gave him the money.
And she's not going to get her car. Perfect.
Title, Judy Justice.
Are you a victim of a scam? Go to judyjustice.tv.
The staff mistreating dogs in their care. What happened that caused you to write this negative review?
She was just saying negative things about our business.
I had heard about some bad business practices.
Tit for tat. You both deserve what you got.
This is Judy Justice.
Brenda Langley is suing business owner Amber Howard for damages and defamation to her pet daycare business.
Court come to order. All rise.
Judge Judy enters.
Have a seat, please.
Kevin approaches.
Hello, Judge. Case 2173, Langley versus Howard.
Thank you.
You're welcome.
Miss Langley, your complaint states that you live in a rural area, 13 acres. Your business is pet sitting.
Correct.
The property that you own does not have running water.
Correct.
So all the water for your property has to be trucked in.
Yes.
The defendant is the owner of? The
owner's wife.
The same thing. They own a water business where they deliver by truck massive amounts of water, and you had used them for a period of time. Prior to Labor Day of 2021, when this incident occurred, how long have you been using the defendants?
Probably about a year.
And how often do they deliver water to your property?
4 times a week. Usually 3 times for the pool and once for the house.
Okay. And each time they came, was that on a set time during the week?
We tried to get a set time, but it varied quite often.
Okay. Would they call before they came?
No.
For the year that you had them, when they came, did you pay them at the time that they came?
Yes, I did. Oftentimes we paid in advance. So we paid for
So
the
you
entire
either paid
week.
in advance or you paid at the time of the delivery?
Yes.
Did you give them a check or cash?
Check.
Now let's get to Labor Day 2021. On what day were they supposed to come?
I believe it was the 4th of September. It was on a Friday.
And who was at home to accept the delivery?
We didn't know when they were coming, but I had taken my employee out to lunch, and I called my nephew, who was there holding down the fort, and told him if they deliver water, let them know I forgot the check, so they can either deliver or come back later.
Well, you live in a rural area. Coming back later is a big inconvenience because you forgot the check.
Yeah, it could be.
Yeah, it happened that it was a big inconvenience because you went out for lunch and you left a nephew. They came, the check wasn't there, and they left with the water. Now, what time did you come?
I wasn't the one who delivered the water. It was my husband, but I believe he had came.
No, he'll tell me.
Oh, okay.
So this was about a year and a half ago. I don't remember the exact time, but it was an AM delivery because we were going out of town Friday evening, going up north. So I was trying to get done with our route fairly early so that we could get
So
out.
the first time you came to the house was in the morning?
That's correct.
Not lunchtime?
No, it was probably somewhere around 10 a.m. if I was to guess.
Okay. And when you got there that one time, the nephew was there?
That's correct.
And tell me what happened.
Well, the nephew, for starters, is about 12 years old, and the reason why we don't necessarily have a time frame for businesses is because if it's between business hours, when we show up and if they need water, usually that shouldn't be an issue for the business.
Don't give me a whole story, sir. The nephew was 12 years old, okay, and he was left in charge of the pets.
That's correct.
Okay, so the nephew was left in charge of these animals, and when you came, there was no check. What happened?
It wasn't even about the money, the reason why I left. The reason why I showed up there is he was talking on the phone, and he said, we are not ready for water right now.
He was on his phone?
Yes.
Where did this conversation take place?
Near the pool, the dog pool. And we were actually taking 4,000 gallons. So I brought my big truck. I'd bring 2,000 for the doggy pool and then 2,000 for the house because it was a holiday weekend, so I had to make sure that we got him enough water to last through the holiday weekend.
Okay, and I assume that the plaintiff was satisfied with your service because she had continued with your service for over a year.
Yes, that's correct.
That's according to you. That's according to you. You had been satisfied with their service because if you weren't, you would have found somebody else. But you had been satisfied with their service. According to you, you paid them in advance or on the date of the delivery. On Labor Day, September 4th, you left your 12-year-old nephew there.
12, but...
Well, how old is he, 13?
He's 15.
So what? What's the difference?
Okay, I'm just
well, maybe he's 15 now. Maybe he wasn't in 2021. So the nephew said to you, we're not ready for water delivery now. Is that what you're saying? Now, your business have a phone?
Correct.
Did the plaintiff ever call you and say, I'm home now, I'm sorry, there was a mix-up?
No, so what happened, I showed up there, he wasn't ready for water. I told him, I go, that is...
What do you have to do to get ready for water?
For their purposes, I believe it was to try to use up as much as they can.
No, don't tell me what you believe. I want to know what you have to do to get ready for a water delivery. Do you have to open up a spigot? What do you have to do?
Okay, so basically they're holding tanks that are in basements or in the ground. So normally nobody even has to be there, well, 90% of our customers. This particular case, one of their tanks is in a basement which doesn't have an alarm. So in order to fill their tank up, somebody has to be down there with a radio to radio up to us to know when to shut the water off.
Okay, so that would have had to have been the nephew, who was between the ages of 12 and 15, would have had to have been in the basement.
That's correct.
Okay. And when you came onto the property, he said, we're not ready for a water delivery.
That's correct.
And he would have had to have been in the basement.
That's correct.
So you left.
Yes, correct.
What happened next?
Your Honor, I told him that it's not that big of a deal. I got a few more stops. I'm gonna go do those stops and then I'll come back. And then hopefully you'll be ready and your aunt would be ready for water at that time. So I went and did my 2 stops. So I used up another 4,000 gallons. I filled back up, went back to their house. At this time, it was probably somewhere around 12. And again, he said, we're still not ready for water.
So you went back again at noon?
Between 12 and 1, I would say.
And the plaintiff wasn't home?
That's correct, again.
How many hours passed between the first delivery and the second?
It takes me about 45 minutes per stop, and I know I did about 2 stops, about an hour and a half it took me before I was back there.
And for that hour and a half, she didn't come back. So it was either a very late breakfast or a very early lunch.
That's correct.
Okay, so now they go twice to deliver water to you, and you're not there, and neither is your check. So now you tell me what happened next.
Kyle called me. First, he doesn't have a phone, but we do have a business line. So he called me on the business line and told me that the driver just left. He goes, I don't know where he went. He said, I think
Who told?
Kyle.
Who was that?
I'm sorry, he's my nephew.
Your nephew called you. What time?
Well, our lunch is...
What? You went
can't tell
before lunch because he was there earlier in the morning.
We did not go before lunch. We went 12:30 to 2. The dogs always nap 12:30 to 2. Okay. We separated the dogs.
How many times did they?
We were
how many?
5 minutes.
How
away.
many times did they come to your house to deliver water?
According to what I was told, I wasn't there. 2.
Well, that's what he says. He came
said 3.
twice. We haven't gotten to the third yet, but he came twice to your house and you weren't there.
Correct.
You're supposed to wait for a service. You're supposed to be there ready for the service. That would be on you. That's not on them, that's on you. They came when they were supposed to deliver water, and you weren't there, and you left somebody who was not equipped to deal with the situation in charge. And what happened was you didn't have water, potentially, over the holiday weekend because they were going away, so you had to scurry to find other water.
Correct.
That's what this case is about.
Caption coming up.
If your preteen or post-teen nephew was on the telephone, didn't want to be bothered at that moment, that ain't his fault. That's your fault that you left somebody incompetent when you were supposed to get a water delivery. All I'm saying to you is, this is nasty a year later. Nasty.
Brenda smiles. A courthouse. The Judy Justice logo appears. In the courtroom, Brenda and Amber and her husband.
Brenda Langley claims business owner Amber Howard defamed her pet daycare business. Amber is countersuing for negative reviews Brenda made toward her business.
Okay, so according to you, a year later, you heard something about their business, so you wrote a negative something about their business on the internet. You'll tell me what that is in a moment. And in retaliation for that, they posted a negative comment about your business, alleging something that had to do with the animals. So that's what this case is about. Your use of the internet to make trouble. You, a year later, according to you, only posted 1 negative review, is that right?
Correct.
And that was a year later?
Yes. Do you want me to tell you why? Because they take the reviews down. You can't leave it.
All I'm
away.
asking you is, I don't want to hear shoulda, woulda, coulda. A year later, you posted a negative review about them. So I'd like to see the review and why you waited a year. You had had a full year of positive service from these people, and the day that you had a problem with them was your fault. I just determined that. It was your fault.
Okay.
So I want to see what you said about them.
Brenda produces a document, then hands it to Kevin. He brings it to Judy, who reviews it.
Miss Langley, so I read this thing. It says, funny how this shows up as a recommendation. Apparently, they took the rating system off their page. They were always shorting us on water for the pool. Well, you used them satisfactorily for a year. So I think that that's baloney.
We had a couple run-ins over it.
Once when I complained, the driver said my nephew told him to stop. What is that about? Once when you complained about what?
About the pool being short on water.
Just what did your nephew have to do with them? Your nephew is hardly a teenager. What did your nephew have to do with discussing
Nothing,
things
really.
with the bro?
Nothing. He would help them sometimes bring the hose in and things like that, but he was just a helper every once in a while.
Well, what does that mean?
He didn't have anything to do with it.
Once when I complained, the driver said my nephew told him to stop. Video surveillance proved he was lying. No one ever approached him and no one spoke to him. I showed the owner the video and he didn't seem to care. The last straw was when the owner, that would be them, left for a holiday weekend and we had no water and low pool water. Well, that would be your fault. You don't say that here. It just makes it appear as if they left and left you high and dry, but they came at least twice, he's going to tell me a third time probably, to deliver water, and you weren't there. When my nephew asked if we could pay next week, he got in his truck and left. That's also your fault.
If you would have communicated, I could have brought the money. We were 5 minutes away.
Just a second. That puts the onus on them. Why weren't you there? This is all on you. This isn't on them. No conversation, no phone call, not even a curse word. I called his wife to find out what happened, and she said they were going out of town for the weekend. And you put in parentheses, too bad. Well, you're allowed to go out. You're allowed to go out for lunch when their delivery is coming without a check, but they're not allowed to go out for Labor Day for the weekend. I immediately called a competitor to bail us out. Thank God he took mercy on us and came out right away. We have had excellent service with a competitor ever since. It could have been catastrophic to try not just to live but run a business with no water over the holiday weekend. You should have been home to get your delivery. And so,
can I say something?
Sure.
I always paid. They knew I was good for the money, and nobody has to be there when they deliver water. We don't watch them deliver water, except for maybe in the house, and Kyle was there to receive it.
Just a second. He just told me that one of the water tanks is in the basement. Somebody has to be there in the basement in your house. If your preteen or post-teen nephew was on the telephone, didn't want to be bothered at that moment, that ain't his fault. That's your fault that you left somebody incompetent when you were supposed to get a water delivery. All I'm saying to you is, this is nasty a year later. Nasty. And for no reason. I don't hear a reason why this a year later. You want to tell me?
I had heard about some bad business practices, so it got me upset again. So I decided to look and find a way to put a review on. They had taken their reviews off the page. So immediately I wanted to put a review on there, but they have it down as a recommendation.
Who cares?
So that's when I left.
I just still don't understand why a year later you stir this up. So for a year, you were getting water from a competitor. You cut off their system. They seem to be still surviving. You're still in business?
Yes. Yeah.
They're in business without you. You're in business without them.
Right.
Okay. So this is nasty. Okay. Now, as a result of being nasty, they wrote a review about you, which is why you're here.
Yes.
About your business.
Yes.
May I see that review?
About her statement saying that she only gave us one bad review, we have proof that we have multiple bad reviews, not just the one, over that course of a year and a half.
May I see, and I'd like to see them. Did you write more than one negative review? Okay, I'm going to take a look at them.
That's what I posted.
Amber produces a document.
Oh, I'm sorry, this is what I posted right here. I gave you the wrong copy.
She hands it to Kevin, who brings it to Judy for review.
Oh, well, this is a different one where you say last water haulers suggested we had to kiss whatever or they would not show. They rarely answered a call or a text in a timely manner. I was even late to a party posted at my home. I had zero water and couldn't shower, couldn't get in touch with anybody. The last straw was Friday. They dropped us on a holiday weekend and said that they would see us on Tuesday.
I don't think that was a review, Your Honor.
Was this not a review?
I don't believe so.
No, it wasn't a review. It was a comment.
Yep.
It was a comment. It was still out there, alive, out there.
Caption, coming up.
So it was really a tit for tat. You got tired?
She wrote that review on my page, so I decided to write a true review about her page.
Perfect. So did I get that all right? Good. A pox on both your houses.
Brenda and Amber grin. A courthouse. The Judy Justice logo appears. In the courtroom, Brenda and Amber and her husband.
Brenda Langley, has accused business owner Amber Howard of defaming her pet daycare business. Amber claims Brenda created negative reviews a year after their dispute ended.
I'm looking to see what you posted about her.
He's got it.
You go, Judge.
Kevin hands a document to Judy, who reviews it.
Okay, so you posted this on October the 30th, and this is on a Facebook?
Yes.
We used to supply water for the puppy pool here 3 times a week, and our drivers witnessed on multiple occasions the staff mistreating dogs in their care. They would see on multiple occasions dog feces in the pool before they would fill it up. We were going to send our dog there before we knew all this, but I told our dog was too small and they could not accommodate him. Now that I know the kind of business they run, I'm thankful I kept my pet out of their care. I would think twice before sending your beloved pet there. And then Lucky Puppy, that would be you. Funny, I just gave you a poor review on your page. The difference is our review was true. Your review is defamation of character. You can remove your untrue statements or you can be sued. Your choice. So now I'm going to ask you sort of the same question. The incident happened on Labor Day of 2021. October 30th, and that would be of 2022?
Correct.
So between the time that they ceased to be customers of yours and a year later, what happened that caused you to write this negative review?
So as you can see in the evidence I gave you, she all the time was just saying negative things about our business. We never had said anything about
so it
her
was,
business.
just a second. So the answer was, it was tit for tat. Correct. It was tit for tat. She was writing negative reviews about your business. So you wrote, which I just determined were untrue. So you wrote a negative review about her business.
Correct.
A year later. I mean, if you were really concerned about the pets, you would have written it immediately. So it was really a tit for tat. You got tired.
She wrote that review on my page, so I decided to write a true review about her page.
Perfect. So did I get that all right? Good. A pox on both your houses.
May I say something, please?
Sure.
So what she accused us of is illegal.
Just a second.
We have to keep sanitary conditions, and we have
Just a second. How do I know that one of their drivers didn't report seeing feces in the pool? How do I know that?
I've been there before and asked them why they didn't need water that currently week, that they're going to need it, the 2,000 gallons on Wednesday like they normally do. And he said we just had to get the dogs out just because we realized there was feces in there. They said it happens a few times a year. So it was not a statement.
Whatever. It's their business, madam. Just like this is your business. If you run a dirty place,
I don't know. That's the whole thing.
Just a second.
My statements were true. Theirs were untrue.
They don't run an irresponsible business. In your reviews, you're suggesting that they are irresponsible and also thieves, because in one of your reviews, you say they were shorting us on water.
Yes, they were.
That's what you say. And you said it not only a year later, you said it during the course of the year. And it was their business. Their business is as important to them as yours is to you. So if you're going to weaponize these reviews, then you both deserve what you got. You're not supposed to do that. If you were legitimately concerned about the dogs, you would have reported it right away. What this was tit for tat, so you deserve each other. Claim and counterclaim are dismissed. Goodbye.
This court is adjourned.
Outside the courtroom, Brenda, then Amber and her husband.
My thing was that they accused us of breaking the law, and it was totally untrue. My statements were true. Whether they were in the wrong or not, they were true statements, and hers were complete fabrication.
I mean, we had been dealing with it for about a year and a half, so I was just really shocked when I received the paperwork in the mail, since I did delete the review, since she did threaten to sue me, so I did delete it.
Look at reviews, and if you can't find them, go somewhere else.
I wanted both of us to be successful businesses, because we live in a small community and our businesses do not, we're not in direct competition with each other. So I wish her well, and I would hope she would wish our business well.
Judy and Sarah.
People like me just learn to look at a restaurant and see what the reviews are. And you sort of assume that people of goodwill, if they're going to post something that's negative, it's because they had a negative experience. And I think it's such a shame that it's become a way to weaponize legitimate reviews where somebody The plaintiff in this case had absolutely no clue that the problem on Labor Day was her fault.
Yeah.
You know, she had a perfectly reasonable relationship with him for over a year. She said they paid him in advance. She never said anything about shorting water.
It's just the power of the internet. I mean, now today, I know there are people that will cancel businesses for reasons completely unrelated to the business, but if you act out, you say the wrong thing, you display a negative character trait in public, people will go to your business's page completely unrelated to anything in the business and just flood the page. I'm talking thousands. They will get thousands of people to write bad reviews about a business, especially if something went viral or if the owners of the business, if they were in a viral video that was not nice. You know, it's the power of the internet and cancel culture.
Well, you know, the internet can be a tool for good and wonderful, or as we know, it can be a very dark place.
Yep.
But it can't be a very dark place without mean-spirited or bad people.
Yeah.
And there are mean-spirited and bad people. You know, I don't know how you protect yourself from something like that. I really don't know how you protect yourself.
The consumer has to be smart in reading the reviews and how much weight they're giving reviews. I like when businesses respond to especially the negative reviews. And sometimes they're funny because if the defendants had responded to the plaintiff's review publicly, you know, so people like you and I who were thinking about using them for water delivery could see it, they'd say, oh, interesting. We called twice and you weren't home and you didn't have our money.
That's the response.
And so I like to see that because it calls out the person who left the negative review. But obviously there's downsides to a business. You don't want to get into a back and forth with every person that leaves a negative review. But sometimes when it's warranted,
you respond to it. But the response isn't to post a negative review about you.
Exactly.
You're right.
Title, Judy Justice.
Have you been cheated? Go to judyjustice.tv.
More than just a pet. She was his companion, his source of solace, and a reminder that even in the most uncertain of times, there was something worth fighting for. The bond they shared was undeniable, and the thought of losing her, of not understanding her past, drove him to pursue every lead. The next morning, Mr. Callan made his decision. He would visit Brookdale Animal Rescue. No more waiting, no more second-guessing. He had to know the truth about Faye's origins. With the address from the package in hand, he packed a bag, kissed Faye on the top of her head, and left for the shelter. The journey to the shelter took longer than expected. The roads were winding and the sky was overcast, giving the entire landscape a gray, somber tone. It was a cold day, and despite the warmth of the car, Mr. Callan couldn't shake the chill that had settled in his bones. Perhaps it was the uncertainty of what he would find at the shelter, or perhaps it was the lingering anxiety about Faye's past. As he approached the outskirts of the town where Brookdale Animal Rescue was located, he saw a modest building in the distance. It was surrounded by trees, and the yard looked like a peaceful, well-maintained area. A sense of calm washed over him, but his mind raced with questions. What if they didn't have any information about Faye? What if he had come all this way for nothing? He parked the car and walked toward the entrance, the sound of his boots crunching against the gravel beneath him. A small sign above the door read Brookdale Animal Rescue. He took a deep breath and stepped inside. The inside of the shelter was warm and inviting. The walls were painted in soft pastel colors, and there were photographs of animals on every wall. Some of them looking hopeful, others looking like they had found a home at last. It was clear that this was a place dedicated to the well-being of animals, and Mr. Callan felt a flicker of hope ignite within him. He approached the front desk, where a woman with kind eyes greeted him. "Good morning, sir. How can I help you today?" she asked. "I'm here about a dog," Mr. Callan began, his voice steady despite the nervousness he felt. "Her name is Faye. I believe she might have come from the The woman's expression shifted slightly, her eyebrows furrowing as if she were processing the name. "Faye, you say?" She looked down at the computer screen, typing something quickly. "Let me check our record." Mr. Callan watched as the woman scanned the screen, his heart pounding in his chest. After a few moments, she looked up, her face neutral. "I'm sorry, sir. I don't see any dog named Faye in our records." His stomach sank, the hope he had been holding on to now slipping through